you're fucking yourself so hard here. Why would he do this? Well, I mean, he deserves to be. Why would you say that? If this protective order goes away, I'm going to engage in the exact behavior that the protective order is enjoining me from. Like, okay, well, that sounds like maybe the protective order should stay in it. So I've seen this.
A lot of people want to act like they're lawyers these days, okay? They do. What is a civil case? Spoiler alert, guys. I lost a civil case. I did. Hey, I did. And we're going to talk about, I lost. It's true. And we're going to talk about everything. What is a civil case? So a civil case is essentially a vibe check to where they see, how were this guy's vibes? Unfortunately, I'm fucking retarded. Yeah, L for me. I'm fucking retarded and I run my mouth way too much. One thing that I've learned, and throughout this slideshow, there's going to be consistent change. I am going to start tweeting 95% less. I uninstalled Twitter on my phone, and I'm not going to tweet for 1 week. Yep, because a civil case isn't determined by proof. It's determined by vibes. And usually the way that court cases work for like criminal cases is you need to have proof to prove that someone's guilty. But in a civil case, I needed proof to prove that I'm innocent, which was hard and I'm a bastard. So essentially, the court decided that I'm a vibe rapist. Yeah, and my vibes were fucking terrible. So the thing that I learned is, Tectone, stop fucking tweeting. Because my vibes are fucking terrible. And I don't think I've ever been on Twitter and done something where I was like, you know what? I'm going to tweet something that's positively going to affect my life. But yeah, the vibes are fucking off. The vibes are off. All right, so I lost the vibe check. It's true. Next up.
So Just Pearly Things used to say stuff like this a lot as well, okay? So people bring this up that civil cases aren't real. So in a criminal case, when the state is depriving you of your life, liberty, pursuit of happiness, whatever, the state is taking rights away from you, right? They're kidnapping you, placing you in a jail, whatever. The state is coming after you, okay? Criminal cases require you to either a judge, if you do a judge trial, or jury in a jury trial, require you to prove beyond a reasonable doubt. There's not a particular percentage, but people say 95, 99%, that there cannot be a reasonable doubt as to whether or not you committed the crimes that the prosecutor is charging you with, that you're accused of, okay? In a civil case is not generally coming after you to jail you. I don't think you can ever be jailed as a result of a civil case. You can be fined or have to pay money to the other side, or whatever tort law you're talking about, or whatever contract you violated that you have to make whole. But in a civil case, it's a 51%, basically. They call it a balance of probabilities, or more likely than not, or there's the balance of probabilities is what they say in the UK. There's another word in the US, or term. I always forget this in the US. But it's more likely than not, basically, that you did the thing. Preponderance of evidence is what they say in the US, okay? So when he's saying vibe check, I'm guessing somebody told him this, like, bro, don't worry, it's just a civil case. They're easier to lose than criminal cases, which is true, but it doesn't just mean it's just a vibe check, right? It's just whatever. Like, it's a lot easier to prove, of course, than a criminal case, but the penalties are not including, like, jail time and everything. Do you think this is how Legal Mindset explained it to him? Possibly. So one is because I think this comment is really stupid. It's very annoying to me. It underplays our civil litigation system. Number one. Okay. Number two, I haven't watched this. Does anybody have a link to this full Tectone video? Because somebody told me that he cites me as like, I had good conversations with this guy or something. And this is basically like he's citing this as supportive evidence. And if that's true, that's very fucking annoying to me, because now I feel even worse for having a civil conversation with him if he's using it to build his credibility or something, especially because this fucker has me blocked on X and I have no idea even why. Maybe because I made that one AI picture of me behind a tree. I don't know if anybody... Go to his channel on his live section. That is about something else, not this topic. Okay, well, I don't know. Maybe that's not as important. The third thing I heard was that the Legal Mindset guy was hardcore sweeping for like every single thing this guy did. Wait, Legal Mindset said it was a vibes check. Is there a link to the Legal Mindset coverage of this? Because that would be nice to see. I'm just curious what all he said about it as well.
reason why that was is because I was not able to defend them. The reason why that was to say, I have had political opinions that I have changed. And the reason why that was is because I was not able to defend them. I was not able to explain why. And I found out that I didn't think that they were too good. Now, for example, Donald Trump. I used to think that the tariffs were an amazing thing. But then I had a conversation with Destiny. And since then, I realized, well, they're actually not as good as I thought they were. And so now I'm more so on the fence. But, you know, when people present me information, I'm...
Oh, okay. That's not a bad statement. Okay. Let's see. And then there was this. What does anybody have the original video this is linked from? Because 11-second clip.
Yeah, okay, whatever. He could get you into collaborations. And obviously he was working with Mythic Talent, and he could get you into Mythic Talent. As somebody who works for Mythic, I think Mythic gets you into Mythic.
3 hours and 10 minutes. Oh boy. And it's part 2? Is there a part 1 to this? Oh, hey, that's me. Oh, we can just look at his fast facts. I don't know if I can go.
The Tectone files. Today we get into a drop of documents regarding Tectone and his ongoing...
He actually cries while reviewing this Tectone trial stuff on stream. What?
Legal saga with his former ex. We're going to get that today on the Legal Minds, where we teach you to be your own judge. I'm Andrew Esquire, American attorney living over here in Asia. And this is a fast facts, the quick and dirty version of the latest in legal news. So let's jump right into the Tectone files. And once again, this is regarding streamer Tectone, who is today our defendant in this case, the Eggman. Now, to be a real quick disclosure, of course, I do know Tectone. He's an individual I'm familiar with, so you could say I have a bias towards Tectone. But that being said, I'm going to try to do this as neutrally as possible and present both sides of the argument. Because remember, there are always two sides of the argument, and particularly in this post-debt Me Too era, we have to consider all of the factors before we just go out and cancel someone for these allegations. And then we've got the plaintiff, Pinkchyu, who is a streamer here. And
how can you and Hassan be the biggest online leftists that spend so much time on air talking about each other and never just do a quick online debate on your biggest disagreements, like who's too scared and why? Hassan is too scared because he doesn't actually have the ability to defend anything he says, and he just has to create a caricature of me to his audience, and he only cares about building clout and shit. He doesn't care about any of the ideas or do any research or know what he's talking about, generally speaking.
And we're going to be getting into their relationship. The important thing to notice being the defendant, Tectone and Pinkchyu, is they dated, right? So these are exes. They had a relationship that is now over. And then you have filings and accusations coming from this, mainly from a drop by Miskiff, who is clearly trying to put information out there that leads people away from his own case at this point. That seems to be his general legal strategy. So let's get into this. This is Pinkchyu.
I don't know how Miskiff dropping things to lead people away from his own case is a legal strategy. I think that's like a PR strategy related to his lawsuit. I don't know if lawyers say legal strategy when you're talking about a PR strategy, but I also don't trust anything YouTube lawyers have to say anymore. These people have been so brain broken about my own civil case, and then I've seen them file other cases. I think that Johnny Depp and Amber Heard did a great disservice to the world by doing anything legally against each other, because they spawned a whole generation of legally retarded dipshits that passed the bar that now do YouTube channels that got way more popular than they ever should have. Holy fuck.
That seems to be his general legal strategy. So let's get into this. This is Pinkchyu versus Tectone over abuse allegations, both emotional and sexual in nature. There were filings both in the civil context and the criminal context. Now, the civil context that was taken all the way to a conclusion, but the criminal context, mind you, was a police report which was dropped. So that is very, very critical here, that there are no criminal conclusions regarding Tectone. And that's something that needs to be very, very much reinforced throughout all of this. Now, Tectone did deny the allegations of Pinkchyu, including her of defamation and filing counter evidence. But Tectone ultimately lost his civil suit and was ruled liable for SA, even despite the fact the criminal case was dropped by police. And this had consequences for Tectone because Mythic, the talent agency, which is also my talent agency, dropped him over this. Now, to be very clear about this, once again, with Mythic, I've made it very clear with them that I would be covering issues regardless of how things look. And with Mythic, they have a right, and I can say this based on my own contract, to drop you based on brand appearance, etc. And many advertisers are
I don't know.
gun shy. So even if the allegations are just allegations, they can drop you. Think about Amber Heard versus Johnny Depp. Johnny Depp, look, and with Mythic, they have a right, and I can say this based on my own contract, to drop you based on brand appearance, etc. And many advertisers are gun shy. So even if the allegations are just allegations, they can drop you. Think about Amber Heard versus Johnny Depp.
True, but they're not dropping it because of allegations. It sounds like they're dropping it because he lost the civil case, right? So
Johnny Depp was dropped by Disney, dropped by other advertisers, simply because of allegations that were not yet proven in court. So this is something that Mythic dropping him doesn't make him per se guilty of anything at this point.
It makes him, it's because of the conclusion that he lost his civil case, right? There might not have been a crime that was prosecuted, but
Other person, by the way, that's involved in this, and we're going to get into this, is Freem, who is a former marriage partner of Tectone. So while she's not necessarily a plaintiff, Freem's information is very much relevant to this analysis. So let's get into the kind of some background here before we get into a word. But actually, before we do that, let's get into a word from today's video sponsor. And now a word from today's sponsor. Sponsor of Data Broke Me. Below. Now, we live in a world that's post-Depp versus Amber Heard, and this is actually, despite what people say, it wasn't Disney, it wasn't Doki, it wasn't anything else that really blew me up. It was Amber Heard versus Johnny Depp.
Ugh, I can't believe he brings this up. God, what a horrible court case for YouTube lawyers to all of these terrible fucking people that blew up on this.
Covering this case. And in this case, BlawTube really blew up because we started covering this neutrally, whereas the whole world in that Me Too era was pro Amber Heard, was pro saying all women believe what she says. And it turns out that Johnny Depp was indeed wronged here and he was vindicated in court. And so when I analyze the Tectone case, I look at this as we are in a post-Depp world. We need to live in a world where we don't believe my dog stepped on a bee and we don't believe any tall tale that came out of what Amber Heard's mouth or anybody else says, because we've seen cases out there in the US that I've covered on this channel, like Trevor Bauer, like the Con case at Princeton, where we have people that are absolutely destroyed. Their careers are just absolutely wrecked based on pure allegation. So let's get into what happened. So all the evidence I'm treating at a higher degree. If it's
I would have to re-look into this. I just Googled this, but I think, wasn't it Johnny Depp won one lawsuit and Amber Heard won the other, right? It was 1-1. So I don't know if, I thought Heard won one of them, the first one, and then Johnny Depp won the second one. But this is, I would have to go back. I'd not say go back. I haven't done this before. I always said I wanted to go back and like read through and listen through the whole Amber Heard and Johnny Depp thing because, it's so much. I just don't trust anything that gets cited by people unless I've read the underlying legal stuff myself, because I don't trust any of these fucking YouTube lawyers.
Just absolutely wrecked based on pure allegation. So let's get into what happened. So
Heard didn't win any. It was the Sun that won in the UK. Okay.
All the evidence I'm treating at a higher degree if it's been filed with the court, not just online. But a lot of this stuff that's been filed that's online was indeed filed with the court. And every individual case has to be evaluated for its impact. So what does a civil case mean? Well, what that means is there's a standard of proof that's lower. It's preponderance of the evidence, 51%, you could say, instead of reasonable beyond a reasonable doubt, which is 99.9% of the time. And such, or up in the upper percentages of happening. But Tectone hasn't been convicted of anything criminal. So for all those out there, and I'm looking at you, all the pikers of the world and everybody else who's throwing the names out there, calling him the R word, and I can't say that because of YouTube, is not actually okay. He hasn't been convicted. That is still defamatory to label him as a criminal when he is indeed not been convicted criminally.
Is that defamatory? Is rapist just a statement on somebody's criminal convictions? If you can't have the opinion that somebody's a rapist without them being, if you say he was convicted of rape, sure, but I'm pretty sure you can have the opinion that somebody's a rapist without a criminal conviction of it.
So one thing, looking at the background here, once again, part one, just look at the background. Travis County in Texas has a huge pro-female bias in terms of outcomes. Women who file tend to get very, very, very favorable outcomes in Texas in Travis County. And there's a potential activist judge who had
So this first statement is not supported by the evidence. Whether that's true or false, I don't know. When he says women that file have a high tendency to win, that could obviously be confounded by the fact that women that file probably have pretty strong cases if they're willing to file, right? This is like the child support argument. Like 90% of dads pay child support to the moms, but like in cases where the dads contest custody, they win like 85% of the cases. Well, probably because when the dads are filing, they have a really high claim, or they've exceeded probably a big bar for winning custody, right? So this first statement is not supported by the evidence, although Legal Mindset is both retarded and biased. So he's legally and mathematically retarded, and he's super biased because he fucking hates women if they can speak English. So this is probably all playing into this.
Who file tend to get very, very, very favorable outcomes in Texas in Travis County. And there's a potential activist judge who had a DV bias, who had a history of that did not recuse themselves in this case. Super relevant. Also
I don't know if this is a federal or state case. For federal judges to recuse themselves from cases requires there has to be a big, you can't just be like, oh, they're biased, or they recuse themselves. Like federal judges very rarely recuse themselves. There has to be a huge conflict of interest there. I don't know about lower courts. I imagine, or state courts. I imagine for state courts, it's probably similar. You wouldn't just randomly recuse yourself. I don't know what he means by activist judge either, and that maybe he just gave decisions that he disagrees with. I don't know, but
jury pool that's biased towards the plaintiff with a skewed heavy female bias, everybody in the courtroom being female, that can tend to bias things when it comes to these outcomes. The other thing, which is different from the Miskiff situation, is we haven't seen abusive communications. In fact, all the communications I reviewed show Tectone as a reasonable, kind guy. He approached Pinkchyu as a friend, not even as a person trying to slide into the DMs, which, number one, is not a crime, but number two, that wasn't how he approached it. He approached this very innocently after he was betrayed in a relationship, which Freem cheated on him with somebody who was working at the same company, so a work partner, right? So after he was cheated on, he ends up engaging in this relationship, which once again, not smart to rebound, not smart to work with somebody, or engage engage with somebody who's perhaps a streamer right afterwards. Dating streamers, always not good, right? Two streamers dating, always not good. But we haven't seen those abusive communications. In fact, when I review the communications, they look much more supportive. And by the way, I'm very, very, very cognizant as someone who struggles with depression myself. This is something I'm very, very sympathetic to for both parts, right? Because Tectone has his own mental health stuff and Pinkchyu has her own mental health stuff. But when I read this communications between the two, it doesn't seem like this is abusive. So Pinkchyu says right here, I have something called PMDD, premenstrual dysphoric disorder, that I'm being treated for. So I'm in a lot of physical pain and my emotions are really bad. Like just feeling so depressed I don't even want to. So on stream today was really, really rough. I'm trying to be tough through it all, but it's not easy when it feels like the end of the world. So please be patient with me. The doctor said it could be 6 months for treatment to fully work. But in the meantime,
I don't know why, if we've got filings and everything on this, I don't know why we're reading tweets unless these were submitted as exhibits to the court case, but okay.
it's awful managing the mood swings and pain. And I understand this. I understand this completely. And so I'm sympathetic to this. And I understand that there may be some other things going in there with BPD or bipolar disorder, something I'm very familiar with. And I get that. I completely get that. She says, thank you to everyone for being so kind to me while I deal with this. I'm sorry for crying on stream. Well, I did that today. Sometimes it's harder holding it in, but I'm hoping by summer it's going to go a lot better to hang in there. It's tough. I get it. It's tough. And what does Tectone say? He says, I will never understand how much this must hurt you, but proud you're fighting through it. And this is not the language I would see of an abusive partner or someone who's hurting or someone who's out there to get somebody, but somebody who
Just the public tweets, bro. This is what we're going on. Verse, like, okay.
really genuinely wants to help and genuinely cares. So Pinkchyu's filings regarding Freem are contradictory. She had filings regarding Freem to get her information taken down because Freem called her a house wrecker, called her all sorts of things, filmed her again without her consent, engaging in sexual activities with Tectone. Once again, several civil and potentially criminal violations regarding Pinkchyu and Tectone that were committed by Freem, and Pinkchyu filed to stop those, which is to me contradictory. And it seems like this may be by sexual activities with Tectone. Once again, several partners, someone's hurting or someone's out there to get somebody, but somebody really genuinely wants to help and genuinely cares. So Pinkchyu's filings regarding Freem are contradictory. She had filings regarding Freem to get her information taken down because Freem called her a house wrecker, called her all sorts of things, filmed her again without her consent, engaging in sexual activities with Tectone. Once again, several civil and potentially criminal violations regarding Pinkchyu and Tectone that were committed by Freem, and Pinkchyu filed to stop those, which is to me contradictory. And it seems like this may be a case of what you call buyer's remorse in dating, where you go back and you say, okay, well, now that I'm out of this, this is a situation where it was buyer's remorse. I regret things I did, or I regret stuff I did, even though it was consensual at the time. And unfortunately, as I got to report to you guys, the U.S. legal system weaponizes this. It allows people to go back, regret things, and then go get protective orders, go make claims in the future when all of this should be dealt with privately. So my judgment at this moment, having reviewed the documents that are out there, is to withhold judgment for the moment pending release of further documentation evidence. We may have stuff that eventually gets unsealed or more communications that come out, more than just what Ms. Kiff is trying to put out to paint some sort of narrative. In a post-debt world, we all need to account for all the evidence taken as a whole before concluding somebody is ripe for cancellation, right? Ms. Kiff releasing these documents clearly does.
What does this have to do with cancellation, with the legal thing? Is this facts from a lawyer about legal stuff, or is this just some ass-pained man who had to fucking flee to Southeast Asia to fuck women that couldn't hear how retarded he is because they don't speak his language, and he just flash $20 bills around? This is the guy, we're just getting his social commentary? Is that...
to take pressure off his case, which contains evidence of abusive communications. Now, I'm not saying Ms. Kiff is guilty yet. I'm giving him the benefit of the doubt too. He's going to have his day in court. But if all he's got is throwing a plushie, that's not going to do enough to get away from all the accusations. And first and foremost, I also think that intimate partner relations are very personal and private. Things can get heated between partners. And you know what? Maybe we shouldn't be dragging this out to the court of public opinion and trying to sue people to make these things right. Maybe.
Well, why did she sue him? What was the initial thing for?
We should handle these things privately as adults between two people. Right now,
I wonder if he had that opinion about my court case. He didn't, by the way. Spoiler alert.
Is withheld, but we'll get back. What do you guys think in the comments below? What do you think about Tectone, the Eggman, and what's going on with him? I'll catch you on the next.
And then he cries. I don't know if I can watch a 3. Well, let's see. Because I've got documents. Maybe if our documents start at the same spot, then maybe it's worth it. The earliest document that I have is filed on the 5th day of November in 2025. But it's referring to an order filed on, or an order granted on August 21st, 2025. So there must be earlier ones. Let's see. Oh, Jesus.
Oh shit, here we go again.
Low, man.
With the Texas right. Stone Files Part freaking 2. And today we've got 225. Hold on. Let me just make sure I get this right. We've got a 2-page document, and then we've got a 225-page document to go through today. 225-page document. There will not be a fast facts that fully covers all this. You've got to watch the live to get all of this. It's a necessary evil, right? To get to this. This is going to be a marathon stream. Maybe go 2 hours, 3. We'll see. 2-3 hours till we get through all this. Yeah. These are all new documents. These have not been seen anywhere else. So anybody doing analysis on this has not seen this, and they do not have all the evidence. They do not have all the information. So the main one, this is the disclosure of the transcript for the hearing on the protective order. I've also got confidential polygraph results that I obtained that are very telling, very, very telling with analysis of this. So
Do they do polygraphs for civil cases? I guess. I don't know if you can use them in criminal things anymore, but
Now, most of you did catch my previous Tectone file stream. 61% of you caught that. If you didn't, you really need to go and watch that other one and get the background. There's not going to be, I can't do fast facts that cover reading through court documents for 2-3 hours. I may be able to get some highlights, and I may try to do that, but it's hard to highlight when you need the full context of all the evidence, all the information. So that's just the way it's got to go down. I'm sorry. But what I'm not sorry about is Dire Measures as a new member. Thank you. I'm doing better today. I was pretty sick. I ate something, so I'm feeling better today as well. I've got a little bit more energy today. Who thinks you're into a legal case? You're putting yourself out there. You're suing somebody. You're putting information out there. You're putting your name on that. Same as becoming a lawyer. As a lawyer, my name is out there, right? In the Bar Association website, right? So your information is out there. You're out there. You're a public figure, right? You're choosing to do that. You're choosing to engage in this process. So reading what is a public document is not doxing, right? So anybody who's out there says, yes, is almost complete. I'm going to scuff it. It's unnatural. Well, I do like to have your beverage choice. For me, it's just water today.
I kind of agree with that. Full disclosure, the Pinkchyu messaged me and talked a lot about this, so I'm going to try not to show doxing stuff just out of respect for this person, I guess. But like, if you are filing a public lawsuit, then I mean, like, the information is public. Yeah, I think her claim is that her lawyers messed up the filings or something, or that it was supposed to be filed under seal, but it wasn't. I don't know how true or not true that is. I haven't dug in deeply to all of that yet, but
today. The Mont Fleur, the water of life, right? Water of life. Not a sponsor of this channel, but we're gonna have a lot today. I'm probably gonna start with the polygraph because it's shorter and we can get this done. But when we get into the actual 225-page hearing on the application for protective order, we'll take some breaks at certain points. Okay. I'll give you a very quick summary for those that just joined on here. This is involving Tectone and his former girlfriend, Pinkchyu, that he engaged in a relationship with almost immediately after he was cheated on by Freem, his former spouse. And
is he just going over this transcript? Is that all he does in this? Because in that case, I don't know. Okay. I guess. Oh, fuck. Then I don't know. Okay. Nizkiff told me that all of the information here that's supposed to be redacted is redacted. If it's not, tell me and I'll take it off stream. But okay. So we have a state of Texas for the protection of this is Pinkchyu versus John Robertson is Tectone. Agreed order for extension of temporary ex parte protective order. So a ex parte means only one party got to make an argument to the court. So Tectone didn't respond to this argument because it was very, very early in the legal proceedings. This is an agreed upon order for the extension of that temporary protective order. So that means that the court agreed, I believe, to extend it. So we have, on this day, the court heard the respondent's motion for extension of a temporary ex parte protective order. Heard the respondent's motion for extension of a temporary ex parte. Okay, well, respondent in this case would be Tectone. Wait, so was it his? Did he agree or did they submit it? Where are my legal people? Interpret this for me. Because this makes it sound like it's his motion for extension of a temporary ex parte protective order. So he filed a motion to extend a protective order. I wish I had the start of this case so I could see what was initially filed. The requirements of a bond are hereby waived pursuant to Section 83003, Title 4, Texas Family Code. It is hereby ordered that the order granted on August 21st, 2025, titled A Temporary Ex Parte Protective Order, is extended until the 3rd day of December, and that this will be the last continuance absent a confirmed emergency. It is further ordered that respondent is ordered to appear before this court in the Travis County Criminal Justice Center, County Court, blah, 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 on the 3rd day of December, to show cause why during the pendency of this case, that one, the temporary ex parte protective order granted herein should not be made into a final protective order, and then two, the court should make such other and further orders respecting the parties as deemed necessary and equitable. Okay, I'm guessing here until a lawyer tells me I'm wrong. My guess is that he couldn't appear in court early enough or didn't feel like his case was prepared yet well enough to do the hearing on why this temporary protective order wasn't converted into something more permanent. So he agreed to extend the current temporary protective order until he had time to get his case together and then show up in court. That's my guess. So he filed a motion to extend the temporary ex parte protective order, and then the court said, okay, we're going to do this one last time, and that this will be the last continuance absent a confirmed emergency. And then you have to appear and show cause, so you have to be able to argue why this temporary protective order shouldn't be made into a permanent one. So I'm guessing that was like the big hearing, basically. Okay. Copy link. These should be referred to as Tectone orders. Good one. Let's see. We have applicant's motion for witness to appear electronically. The motion for witness to appear electronically. This case is currently set for a final protective order hearing on January 23rd, 2026. Wait, hold on. Does that mean that it was extended again? On the 3rd day of December 2025. I guess it did get extended again. Who knows why? Okay, whatever. As a convenience to the custodian of records of Andrew blah, 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 the petitioner requests that the court allow the custodian of records of Andrew Peter to testify via Zoom video conference at hearing in order to authenticate records obtained from this person. Okay, so this is just an application for some witness to appear electronically and not in person. I think generally judges like it when people are there in person. I don't think they generally appreciate electronic appearances unless there's some reason why. Why does this case have have a docket like Tiny's? I don't think this is a federal case. I have a docket here. It's archived. But I don't know if all this stuff on here is censored or protected or not, so I'm not trying to go through that one. But I don't think this is filed in federal court. So there's not going to be like a nice PACER document thing or like a court reporter document thing. Oh yeah, I mean, county clerk, Travis County, Texas. Okay. Okay, and show cause order. On this day, the application of applicant for the expedited protective order was presented to the court. Applicants request honorable court to issue an expedited protective order pursuant to Chapter 83. This court, having examined the pleadings, supporting affidavit the applicant and having heard testimony from the applicant, finds that there is a clear and present danger that acts of family and or sexual violence will be committed by a respondent before a full hearing can be held upon applicant's request for protective order. Applicant and or the other members of the family or household who are affected by the suit will suffer immediate and irreparable injury, loss, or damage for which there is no adequate remedy at law unless respondent is immediately prohibited from the acts set forth below. It is therefore ordered that the clerk of this county court issue a temporary expedited protective order prohibiting respondent, and respondent is hereby immediately prohibited from. Okay. Filed on. Oh, is this the initial? I'm just looking at these in the order that Miskiv sent me. Okay, August 21st. So this is, I think, was the first protective order filed. So when lawyers say, like, don't talk about your court case publicly, you just shouldn't. But the reason why you shouldn't is because a lot of things can come back to bite you in the ass. Even if you're smart, they can come back to bite you in the ass in ways that you're not fully aware of. Like, there might be certain arguments that you cut yourself off from making just by saying certain things publicly, or worst case, you might violate orders that have been issued by the court if you're not careful. So when Tectone said, I need to stop tweeting stuff, I wonder if he just means tweeting crazy stuff in general, or if he was doing stuff that was actually violative of the protection order. So respondent is hereby immediately prohibited from, so this starts in August of 2025, I think, August 21st, 2025. Committing acts of family violence, sexual assault, and or stalking. I don't know how stalking is defined. I'm sure it's somewhere in the Texas code we can find. Destiny, can you give us an example? Like, what would you say that would hurt your court case? For mine, depends on what they're asking for or what they're trying to say. Like, if I were to say things, like, let's say they're trying to make an argument for the preliminary injunction, right? Let's say I was tweeting out things like, you know what, fuck Pixie, I hate her. Like, I'm going to just upload all of our videos because I hate this bitch so much, right? They could take that tweet to the hearing and they could go, oh, look, he said he was going to upload all the videos. We need a preliminary injunction to prohibit him from doing these things or whatever, right? You could say stupid stuff like that could sway a judge's argument in favor or against certain motions, or ultimately, you know, verdicts. You know, there could be evidence submitted to trial that might be used to prove, you know, motivations or parts of it. It just depends, right? Communicating or attempting to communicate with the applicant or any member of the applicant's household in a threatening or harassing manner. The court further finds that good cause exists to order respondent not to communicate with the applicant in any manner whatsoever except through attorneys, and it is so ordered. I wonder if this includes tweets and stuff. Going within 200 yards of the persons and places listed herein, except as necessary for court proceedings, removing the children named herein from applicant's possession, or removing the minor children listed on the application for protective order from Travis County, Texas. Children. I don't think there are children involved, right? This might be like a boilerplate protective order, maybe. Damaging, transferring, encumbering, or otherwise disposing of any property mutually owned. Tracking or monitoring personal property or a motor vehicle in the possession of applicant or of a member of their household or family. Interfering with the exclusive use of applicant's residence. Injuring, harassing, threatening, or harming applicant or the children. Okay, harassing. Engaging in conduct directed specifically toward applicant or a person who is a member of applicant's family or household, including following that person that is reasonably likely to harass, annoy, alarm, abuse, torment, or embarrass that person, or stalking that applicant is defined by section 42072. Harming or causing harm to come to or removing from the possession of the applicant or any member of the applicant's family or household, any pets owned jointly, blah, 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 okay, possessing any firearms or ammunition unless he or she is a peace officer as defined by section 1.07. Oof, okay. Damn. I'm just curious here how Texas defines stalking or whatever. 42072, right? A person commits an offense if the person, on more than one occasion and pursuant to the same scheme or course of conduct that is directed at a specific other person, knowingly engages in conduct that one constitutes an offense under section 4207, or that the actor knows or reasonably should know that the other person will regard as threatening. It could be bodily injury or death for the other person. Death, killing them is probably threatening, sure. Or that an offense will be committed against a member of the other person's family, individual with whom that other person has a dating relationship, or other person's property. Cause the other person or a member of the other person's family or household, or an individual with whom the other person has a dating relationship, A, to be placed in fear of bodily injury or death, or in fear that an offense will be committed against the other person, a member of the other person's family or household, to feel harassed, terrified, intimidated, annoyed, alarmed, abused, tormented, embarrassed, or offended. Okay. Are these all elements of, so all three of these need to be met? An offense, okay, so they need to be threatened by, or is it one of these three? I don't see the or at the end. Okay, so I'm guessing is that all three of these need to be met? And then 3 would cause a reasonable person under circumstances similar to the circumstances of the other person to fear bodily injury or death for the other person, or for the person fear that the offense will be committed against a member of the... Okay. Okay, I feel like this is fairly broad. So my guess is going to be that like tweeting, intimidating stuff... Sorry, is this text small? It's kind of small, sorry. Tweeting, intimidating stuff, my guess would probably qualify under this. That's going to be my guess. I don't know if that'll come up or be relevant or not, but okay. This kind of looks like a boilerplate temporary protective order that was granted by the court. Damn, he had to surrender all his firearms as soon as this was possessed. He was supposed to. Okay. The fuck is this? Okay. 1, 2, 3, 4. This is the next thing. Copy link. This is August 27th. Do you have to surrender guns to the court? I don't know how this works in Texas. Usually there'll be some process, I imagine. Either surrendering it to cops or to somebody else. I'm not sure. I don't know. An application for protective order has been filed in the court, stated in this notice, alleging that you have committed family violence. You may employ an attorney to defend you against this allegation. You or your attorney may, but are not required to, file a written answer to the application Any answer must be filed before the hearing on the application. If you receive this notice within 48 hours before the time set for the hearing, you may request the court to reschedule the hearing, not later than 14 days after the date set. Okay, true. You are commanded to appear September 3rd, 2025, to show cause, if you have any, why this application for protective order should not be granted. Okay, so she filed a protective order, gave enough evidence to the court to feel like, okay, we can grant this. This is the notice sent to Tectone saying, hey, just so you know, this has been filed against you. If you want, you can show up before or on this hearing basically to argue why this shouldn't be granted. Against you. This is dated 8/27/2025. This is also dated August 27th, 2025. Respondent, the applicant has filed an original application protective order asking among other things for the granting and issuance of a temporary ex parte order to restrain the respondent, blah, blah, blah. It's fully set out and prayed for. To restrain, and you, the said John Robertson, are hereby restrained as fully set out and prayed for in the application for protective order and temporary ex parte protective order and show cause order, a copy which is attached herein. Okay. I guess most of the juicy stuff is just going to be in the hearing, I guess. That's okay. Let's just go through these to have some background. August 28th, the next day, to the Honorable Judge Dimple Malhotra. Please be advised that I represent Tectone in regards to this case. This case is currently pending in the county court at this here. Please direct me to correspondence. Okay, so this is basically just putting the judge on notice that he's the official representation for Tectone. August 28th, to the Honorable Judge of said court comes now. This is a motion for continuance. I think that continuing a case, continuance is basically just stalling or delaying a date for the next hearing or whatever. Comes now, the respondent moves his court to continue the above entitled and numbered cause and would show that this cause is currently set for protective order hearing on September 3rd. And they're asking to... The respondent would also show this court that attorney Jeffrey Brewer has requested additional records to be provided to her office and request additional time. On August 26th is an agreement with that request for continuance. This motion for continuance is not made to cause delay. I don't know if the court picks the next date or if they're allowed to request the next date. Maybe the court chooses, I guess. Okay, that's the motion for continuance. We've got on this day, the court heard the respondent's motion for extension of a temporary ex parte protective order. The requirement of a bond are hereby waived. Okay, so this was him requesting an extension of the protective order, potentially to continue the case, I guess, is why he would want to extend it so that they have more time to respond. Blum, blum, blum. Agreed. Wait. Agreed order for extension. Application for subpoena. Why the fuck did this court case go so quick and yours is taking so long? Technically, this... I'm speaking a little bit out because I don't know yet. Technically, this is not a full court case. I don't know if this even made it to a formal discovery stage. This is like a preliminary injunction type thing that you are asking for, a temporary restraining order. Like this is like at the pleading stage of the case. And then I think that the evidentiary hearing that they had relating to that, to hear arguments from both sides, I think that this is a thing that's just decided by a judge. So technically, I don't even know if you would say he lost a court case or he lost it. I think he just had a bad ruling on a hearing. I don't know if you would say that. I don't know. We'll see. As we get into it, I'm not sure yet. We'll see. Application for subpoena. The judge of this, you will please issue a subpoena in accordance with the law in the above styled. Testimony's material. Okay, so this is them trying to get I guess a police officer to it's material to the respondent. So this is Tectone trying to subpoena a police officer in order to get her testimony for this hearing. It's material to the respondent. Okay. Testify as a witness on behalf of the respondent in the above styled and numbered cause, and there to remain from day to day and from term to term until discharge here and fail. Okay, that's that. Agreed order for extension. Did he send me the same thing a bunch of times? Or is this another extension? Extended till the 3rd of December. Okay, boring. Fifth day of November. Okay, what is this? November 14th, 2025. Records request for cause number, application first general respondent. Counsel for respondent. So this is Tectone's lawyers respectfully requests a certified copy of the ex parte order for records signed, granted, and filed into the case here. Okay, copy. So they're requesting a certified copy of the protective order to register or file with the case, I guess. I don't know. Okay. Okay. Disclosure to the public or state is prohibited. Ex parte order on respondent's motion for court on the date set forth came to be heard. The respondent's foregoing motion and the court, after due consideration, hereby orders that the same motion is hereby granted. Therefore, it is the order of the court that Austin Oaks Hospital is commanded to produce all items, documents, or things in their possession regarding treatment records for Pinkchyu. Said production shall be made in full and return sent to the defendant within 30 days. How does this work with like HIPAA stuff? Can you really request, you can request medical documents in violation of HIPAA, or maybe HIPAA has built in if it's a legal request, that's okay. And then obviously these documents must be made available to Tectone. They're not to be made available to the state, disclosed to the state nor to the public. So they can't be filed on the court docket, I'm guessing. The full documents or whatever, and they can't be published publicly anywhere. So it seems like he was made, these documents were made available to him. Let's see, disclosure to the public or states prohibited, ex parte order on a respondent's motion for... Wait, is this what I just opened? I think this is just what I just opened. Hold on. Are these exhibits, I'm guessing? Hi all. E-file has been down for over 24 hours and this order needs to be filed. Afternoon, after reviewing the attached order, we find the wording district clerk should read. County clerk, maybe we have this corrected. Thank you for your attention to this matter. Good afternoon. Please make the correction. Thank you. Okay. Exciting. Comes now Tectone, buying through his attorney, and files the defense notice of filing business records with accompanying affidavit in support thereof, which show the following under Rule 902 of the Texas Rules of Criminal Evidence. The defense hereby gives notice of filing the following business records. Some records from the Austin Oaks Hospital. Okay. On blank, somebody appeared before me, or Samantha? And after being placed under oath, affirmed the truth of the following. My name is something, that's not Pinkchyu, is it? Hopefully not. I'm over the age of 18, of sound mind, as a custodian of records for, oh no, the custodian of records, okay. I've attached 126 pages of records. Records are kept within the regular course of business by Austin Oaks Hospital. Okay, just saying that the records that they submitted are real and true. Okay, this is the nurse, yeah, I guess, or whoever's in charge of the records for this. Let's see. December 2nd, this agreed motion for extension of temporary custodial order is brought by applicant Pinkchyu, who shows in support. This case is presently set for trial. On applicant's request for a final protective order on December 3rd, the parties have agreed to reset the trial on applicant's request for a final protective order from December 3rd to January 8th. Okay, so this was okay, and to extend the temporary protective order. Okay. Like I said, my guess is most of these are going to be pretty boring until we get to the actual hearing, I'm guessing. Applicant's motion for substitution of counsel. Request the court to grant permission to substitute Michael L. Locke as attorney of record in this case. Michael L. Locke. Okay, this is just like declaring to the court who's representing by applicant would be Pinkchyu. So she's changing out a lawyer or saying that somebody else is going to be part of their legal counsel, I think. Whatever. Okay. I think of like 6 more of these random things before the hearing. Let's see, approving of a subpoena, I think. Or this is a request for a subpoena. What is this? Hold on, let me just go through these on my computer. We have a motion for continuance of the case. I think Ms. Double sent me these ones. Application for subpoena. Is this a different one or the same one? I think it's the same one, okay. To appear on January 23rd. Oh, maybe to get her to appear at a different time. Motion for extension of protective order because of the case being applicant filed a motion for continuance seeking to reset the current trial setting. Applicant contends that extending the TRO would result in no harm. Applicant contends that if the temporary ex parte protective order is not extended, applicant will suffer harm as evidenced by respondent's social media postings, which applicant believes are threatening or harassing in nature. Oh, wait, hold on. What is this? Uh-oh. They're going to hate what I found today. Your loss is now even more inevitable. Now I wait, smiley face. I banned this guy from my chat 3 years ago because he was mad I wasn't enjoying Genshin Impact anymore. Okay. He's subtweeting a victim of sexual assault. Okay. I shouldn't say I'm pulling this out of my ass because none of these fucking fake YouTube lawyers do this. Hedge it all. Even though she included these tweets, they might not have been necessary for the extension of this protective order. My guess is a judge is probably almost always going to extend the protective order up until they finally do this final hearing. But it never hurts to throw stuff in like this for your thing. So even if you hadn't tweeted this, my guess is going to be there's a good chance that they probably would have extended it anyway, but man, if somebody is fighting for a protective order against you and part of their argument goes to harassment, harassing the person or being harassing towards the person on social media, probably not a great idea. But, okay. Let's see, motion for witness to appear electronically, and then motion to seal. This is January 23rd. The motion to seal records and motion for confidentiality order is brought by this applicant who should support. This is an action originally arising out of the Texas Family Code. The documents filed in this case are not subject to the standards for sealing court records set forth. Oh, I don't know if, again, I don't know the standard procedure for any court case because I don't practice law. But if I had to guess, it's probably a mistake to file this motion to seal records at the end of the case. My guess is you probably should have filed this initially if you wanted all of this stuff to be sealed. That might be why so much of this was made public and she didn't want it to be or wasn't aware of it. Now, maybe for the rules of civil procedure for Texas courts or for family law or something, maybe there's a reason why you can't do this. Maybe you don't have the option to do this initially. I don't know. But this is an action originally arising out of the Texas Family Code, and the documents filed in this case are not subject to the standards for sealing court records set forth in Rule 76A of the Texas Rules of Civil Procedure. If that's the case, I feel like you could have filed this right in the beginning of the case, so none of this would have been filed publicly. That'd be my guess. I could be wrong, but standard for maybe there's something here for when you're allowed to file the stuff. The standards for sealing court records. Court records may not be removed from court files except as permitted by statute or rule. No court order or opinion issued in the adjudication of a case may be sealed. Other court records as defined in this rule are presumed to be open to the general public and may be sealed only upon a showing of all of the following. A specific, serious, and substantial interest which clearly outweighs this presumption of openness or any probable adverse effect that sealing will have on the general public health or safety, and no less restrictive means than sealing records will adequately and effectively protect the specific interest asserted. Let's see, court records. Purpose of the ruling, court record means all documents of any nature filed in connection with any matter before any civil court. Settlement agreements not filed of record, discovery, notice. Court records may be sealed only upon a party's written motion, which shall be open to public inspection. The movant shall post a public notice of the place where notices for meetings of county governmental bodies are required to be posted, stating that a hearing will be held in open court on a motion to seal court records in the specific case, that any person may intervene and be heard concerning the sealing of court records. Okay, a hearing open to the public on a motion to seal court records shall be held in open court as soon as practicable, but not less than 14 days after the motion is filed and the notice is posted. Temporary sealing order on motion to seal court records. Motion relating to sealing or unsealing court records shall be decided by written order open to the public, which shall state the style and number of the case, the specific reasons for finding and concluding whether the showing required by paragraph 1 has been made, the specific portions of court records which are to be sealed, and the time period for which the sealed portions of the court records are to be sealed. The order shall not be included in any judgment or other order, but shall be a separate document in the case. Maybe it's the case then that you have to specify which documents you want sealed, in which case you have to file it afterwards, maybe. Although that seems kind of self-defeating. Like if I want something to be sealed, but I have to file it publicly first, that seems kind of shitty. Any person may intervene as a matter of right at any time before or after judgment to seal or unseal court records. Access documents, court files not defined as court records by this rule remains governed by existing laws. Rule does not apply to any court records sealed in action. Okay, I'm not sure. Leon said, these are practicing attorneys and they never thought to file under seal. Oh yeah, Leon, that would be my question. Like I know for federal court, obviously for my case, I know that you can file these like kind of protective orders or these motions to seal before you file the documents. It seems a little bit self-defeating to file this at the very end of the court case. Although, when did Mizkiff initially leak all these documents? Maybe they didn't realize, or maybe they just fucked up. It might just be a fuck up. Or maybe the judge or the attorneys for Pinkchyu didn't realize that she wanted them all filed under seal, maybe. Maybe they don't usually do like streamer or public interest cases, so it's just not a thing they thought. Maybe. That's my guess. But, okay. There's all that. All right, and then we have, I guess what was ultimately the transcript of the hearing, which is 225 pages. Oh boy. Did Mizkiff not send you the application for protective order? I don't know if I have that. Application for subpoena. I have the orders themselves. I don't know if I have the application. I don't think I have that. If you have a link to it somewhere, then Send it to me. All right, transcript review. Hold on, we'll start reading it. 1 sec. Okay. Check DGG DMs for the doc. Wait, how the fuck do I? Oh. This is posted on Kiwi Farms. It is full on docs. Don't show on stream. Is this all Is this publicly filed? Hold on. August 21st. Do I have this? Oh, I have this one filed, but not with the I guess the evidence attached? Okay. Request for confidentiality pursuant to 85. Oh, they did have this request for confidentiality in the initial application for this protective order, so. The applicant requests the court to exclude the following information from the protective order: the mailing address, county of residence, and telephone number of the applicant, and any person listed in the application as a person in need of protection. Oh. I wonder if they just disagreed with that, or... Let's see. My name is Pinkchyu, and I'm a resident of this county. I'm reading the order, but I'm not reading... I just want to read the... I guess the information she wanted sealed. The facts stated herein are within my personal knowledge and are true and correct. I wish to file a protective order on behalf of myself. I wish to file this order against Tectone, resident of the same county, and the respondent in this case. An incident occurred in Travis County, or in this county, or it's the county where they don't live, whatever. The relationship between the respondent and myself is we previously dated. We have lived together in the past from December 2022 to July 2024. We have 0 children. He committed the following acts constituting sexual and physical violence in May 28 or 29, 2024. It seems like a forced blowjob incident on May 28th or 29th of 2024. No, but I later reported this incident to the police on or around January 22nd, 2025. Date of incident, 2024. Was another, it kind of sounds like forced blowjob incident, I guess, in 2024. And then reported this incident to the police on or around January 22nd, 2025. And then March 2024. Sounds like another forced blowjob incident. Jesus. Also reported on January 22nd, 2025. When I first moved in with John in December 2022, he told me that instead of paying rent, I'd have to perform oral sex on him whenever he wanted. I felt like I had no other option but to comply. Okay. Around February, March of 2023, I told him that I didn't want to live by this agreement anymore and told him I'd pay him rent instead. Okay, so 2 or 3 months went by. However, after this, he found other ways to coerce me into performing oral sex on him when I didn't want to. For example, he'd remind me of items or meals he bought for me and tell me that I owed it to him. If I didn't comply immediately, he'd repeatedly guilt trip me until I complied. Throughout the time I lived with him, John would also record me when he wanted me to perform oral sex. There were multiple instances where he'd record these moments without my consent. There were also at least 2 incidences where during oral sex, John pushed my head onto his penis hard without my consent, causing me to throw up. These incidents happened so often that it became difficult to remember when each one occurred. After I moved out in July 2024, I made a post on X about my experience as a victim of sexual coercion, but I did not identify a specific perpetrator. John then threatened to post revenge porn of me if I didn't take the post down. This made me very afraid because I knew he had recorded me in the past. He'd also consistently live streamed or posted rants online. What did she post in July of 2024? Does anybody have that post? On or around January 15, 2025, John made a post on X saying he would publicly post text conversations, videos, etc. between him and I online. I worked with an attorney to have John served with a cease and desist on or around January 24th, 2025. Despite this, he continued to make posts about me on X and Twitch. Posted a live stream where he called me a liar and threatened to sue me. I've not heard directly from John since November 22nd. He accused me of swatting him on or around August 16th, 2025 and said, "The world will know what you've done." Late October, early November. That's when. Every day I'm afraid John will act on his threats to post intimate videos or photos of me, and I fear he won't ever stop posting things online about me. Okay. Okay. And I imagine, does she post evidence to the court in separate exhibits, or can she just state these things and they're just taken to be true without, where she doesn't have to show any evidence to the court, like no text messages or whatever, is my guess. So these maybe would come out in a hearing. I'm curious why she made the tweet talking about her experiences with sexual assault. And then I'm curious why he kept responding publicly. Like, I wonder if there was some provocation back and forth between both of these people. I don't know. I just don't know. This article has some tweets, including one from 2024. There are tons of examples of BS accusations. Is this type of allegation and emerges good examples of statements about SA? I don't want to on the bad side of big titty goth queen, okay? I don't know why she would make public statements about this. I just don't understand this thing where, like, I need to comment publicly on I don't understand this. I don't know why people do this. How are you supposed to feel if a guy is abusive, makes you cry, and then shoves your head on his crotch and demands you suck him off, and that his excuse is emotion just turns me on when you cry? Like, I don't know what the point of stuff. I don't know why. I just don't know why. I can understand Tectone responding to it to some extent, because I think most people, I feel like I vaguely remember this. I think most people put together very quickly that this was Tectone, even though she hadn't mentioned him, because I think everybody knew that they had dated. Yeah, I guess I don't know. But then if Tectone is making threats or whatever towards her, or is continuing to talk about her for a year after, that's also kind of not good. I don't know. I also don't know how bad these situations were in person, though. And it's hard to evaluate, obviously, because we have both sides of the story. Like, if it's really as bad as she describes, like, I mean, that's pretty shitty. That's pretty bad. Okay. Well, all right. This is the hearing on application for a protective order. Where's Leon? Is a protective order technically an injunction? You're enjoining some party from doing something? Is this particular case, was this a do you call it a bench trial where just the judge makes the decision and it's not a jury trial? What do you call it? Jury versus bench trial. For women, often going public is the greatest way to defend yourself against shit like this. Well, but she was already out of the relationship, right? That's why I don't understand. I don't know why. But okay. On the 23rd day of January 2026, the following proceedings came on to be heard in the above entitled and numbered case before the Honorable Dimple Malhotra, judge presiding, held in Austin, Travis County, Texas. Proceedings reported by machine shorthand. The court. Anytime it says the court, that's going to be the judge. Let's go on the record in this cause. This is an application for order of protection in the name of Pinkchyu, listing the respondent as Tectone. If I can have both sides, please state your appearances for the record. This attorney, I am Michelle Locke and Caitlin Boland on behalf of Pinkchyu. We're ready to proceed, Your Honor. All right, thank you. And then Mr. Puryear and Jeffrey Puryear on behalf of Tectone, the respondent, ready to proceed, Your Honor. All right, thank you. And are there any preliminary matters that we need to address at this time? Pinkchyu's lawyer, I'm just going to call her Mrs. Locke from now on. A couple of preliminary matters, Your Honor, just housekeeping. We have a motion to appear electronically for one of the custodian of records from a doctor's office. The judge says okay. We've been trying to subpoena them for 2 weeks, and they said it was difficult and having to deal with attorneys, but they have agreed to make the records available electronically. So we did file a motion for that. We also filed a motion as it relates to sealing the medical records in this case. The court, there have been 2 subpoenas. One was issued by opposing counsel, and they obtained mental health records of our client without a release. We have concerns about, based on the history of the parties and the history of this case, that information being disclosed. And so we'd like that any medical records that get admitted into evidence be put under seal, and so we filed a motion for that as well. The judge says okay, and Mr. Puryear, let's take up the first motion to appear electronically, and that was for the custodian of records. Any objection? Tectone's lawyer, Mr. Puryear. I have, I guess, a clarification, Your Honor. The doctor whose office prepared those records, there is some matters of, I think, potential credibility and impeachment that may be difficult, kind of just given the confines of electronic testimony, but I'm happy to attempt to navigate those, and we can take those up if they come up. Okay, wait. So this is a hearing on the this is a hearing on a restraining order. Is this like the whole court case? Is it, because it's just, I guess they're just seeking a protective order. So then is this essentially like a bench trial? Or is it just a hearing because there's not going to be, like, would it only become a jury trial or something if there was a dispute on a factual matter? Or what is I'm just trying to understand, like, what is this hearing? Are we to understand that this is like the bench trial? Because they both agreed to a bench trial? If they would have asked for a jury trial, then this instead would have been presented as at trial? 3 hours of Hutch and Pisco arguing about leftist treatment and in-out group. It was something. Gee, that's why I didn't listen to that live, okay? The judge is just ruling on a motion. Yeah, but like, what if the motion is the whole court case, right? Pretty much the entire case is that order, yes. Okay. Like if the judge granted the order and it's briefed by both sides and basically the whole order is the court case, would you even go to trial? Or I don't know. Okay. The judge says, okay. Pinkchyu's lawyer, Mrs. Locke, and judge to clarify, it is solely the custodian of records to authenticate the records because the records speak for themselves. We are not anticipating calling the doctor. The judge says, all right, that motion will be granted. Mrs. Locke says, thank you. The judge says, all right, with respect to the second motion to seal the medical records, any objection? Mr. Puryear, no, Your Honor, no objections. All right, that motion is granted as well. Man, they just rapid fire motion granting in court. Must be nice. Anything is nice, just kidding. Okay. Leon's law says you only have a right to a jury on money issues, not equity remedies. That's interesting. Okay. Considering his Second Amendment rights are kind of at stake here, you wouldn't have a right. That seems kind of weaselly, no? But okay. Anything else we need to take up at this time? Mrs. Locke, I think that that's it for preliminary. The judge has given that I've granted the first motion for the custodian to appear electronically in terms of timing because we're going to need to generate a Zoom link and provide that to you, to both parties. So when were you intending on calling this witness in terms of the order? Ms. Locke says, after I call my client. The judge says, okay. And I would assume that on break, opposing counsel and I can talk about whether those records can just come in for purposes of authenticity, is why we're having the custodian of records, but we can discuss that on break. So it sounds like they want this custodian as a witness just to basically say the records that are being submitted are true. They don't really need their testimony for anything other than it's basically like an affidavit or declaration saying I testify that all the records I'm submitting are true and from the whatever Oaks, Austin Hospital, whatever the fuck it is. So the judge says, okay, sure, okay. So, and then just looking at the time, I would imagine that we would probably take a break around noon. That works for me. Okay. Are there any witnesses in the room? I don't have any witnesses in the room. Okay. Mrs. Locke, do you wish to make any open remarks at this time? Briefly, Judge, if the court would allow. Please, of course. Thank you. This case has been pending, Judge, since August 21st of 2025, and it's a protective order based on sexual assault as well as stalking and harassment. And we'll get into the issues of what has occurred, but to give the court some background, these parties are streamers. Foreign concept to me. I've learned more about that in the last couple of months than I ever thought I would. They have an immense amount of following, and I think Mr. Puryear, at our continuance hearing on the extension, mentioned and made references to the parties being like that of Brad and Angelina, but of like the Twitch streaming, but of like the Twitch streaming that they do for online gaming, and the parties have a relationship. The court will hear details of the nature of the sexual relations between the parties that gave rise to the claims of sexual assault, where the court will also hear evidence of how it came that my client, Pinkchyu, came to live with opposing party, Tectone. It was kind of a bait and switch. It was, hey, come here and help me with my social media move in. You can live rent free. And when she moved in, it became, oh, hey, well, you need to give me oral sex to compensate for your rent. So you're going to hear some information about coercive control. You're going to hear that he recorded her without her consent in sexual acts. You're going to hear, Judge, that he would demean her by having her write slut and come here on her face before he made her perform oral sex. What you're also going to hear about this case, Your Honor, is that they had never actually engaged in traditional intercourse. It was only ever he received blowjobs, and there was never any reciprocation on to my client. In addition, there was never any really kissing. He would want to spit in her mouth, but she refused. And so you're going to hear a lot about, and I think what you will hear, Judge, is that my client and the evidence will show that my client had been raped before, a pretty ugly rape in her early 20s, and knew what that was. Didn't understand until she got into this relationship how bad it was. And then what you will see, Judge, is that he used his platform from the time they broke up until the court signed that emergency protective order in August of 2025, that he went on a consistent rampage against her on social media. The court will recall at the last hearing, the court said, I will caution the parties to stay off social media, especially as it relates to this case. And Mr. Robertson, Tectone, that day went and posted something about the case. And so what you will see is his consistent threats on social media, wherein he has told the audience of over 1 million subscribers that he suffers from schizophrenia, that he has delusions at least once a month, but they're relatively controlled. He has also said in additional social media posts that he will take her down, that he will expose the truth. He goes on rampages about women, etc., etc. That's what my client and the evidence will show, is that since this protective order has been in effect, my client has had peace for the first time since they broke up because he has, for the most part, been retained in what he's allowed to do online. Okay, oof. And the concern is based on his own statements to his streamers, and we have the videos, Judge. that if the protective order goes away, that my client's life will turn into a nightmare again. Oh, why would you say that? Okay, he's fucking retarded. This is not just saying random shit. This is, you're fucking yourself. You're fucking yourself so hard here. Why would he do this? Well, I mean, he deserves to be. Why would you say that? If this protective order goes away, I'm going to engage in the exact behavior that the protective order is enjoining me from. Like, okay, well, that sounds like maybe the protective order should stay then. Yeah, assuming he said this. Now, keep in mind, this is just the argument that's being presented. This is the strongest form of the argument that's being presented by Pinkchyu's lawyers. They could be lying about everything, right? Hopefully, at this stage of the proceedings, they wouldn't be, but just saying this is the argument that they're making. My client is on the spectrum for autism and suffers from some anxiety disorder. It's a really unfortunate case. And what is difficult about it is because both of these parties earn their living from social media and streaming, that any effect that he puts on social media and then the threats, they get back to her. He knows that he can get back to her, and he knows that it can affect her business. And the court will hear a little bit of details of how the online streaming works and compensation. But it was very much, she thought if she left him, that all of her social media and all of her income would go away. But at the end of the day, we're asking the court to grant a protective order for the appropriate time period. This court determines under the statutory authority and orders attorneys' fees in connection with the granting of a protective order. All right, thank you, Mrs. Locke. Mr. Puryear, Tectone's lawyer. Mr. Puryear, thank you, Your Honor. Judge, just very briefly, I think that the court is going to hear what the court is going to see for itself in documentation that will be offered, and my expectation will be admitted, is that the summation of the relationship could not be farther from the truth. I think what you will hear is that the applicant was the one that reached out to Tectone to begin a relationship, and that a romantic relationship was begun in December of 2022. And that romantic relationship progressed, as many do, and they moved in together. It's true that the applicant never paid rent. What I think you're going to hear is that Tectone had a male roommate who didn't pay any rent either. Tectone has been fortunate in his finances. He makes pretty good money doing what he does, and he is happy to accommodate friends, romantic relationships in that way. There was never any quid pro quo associated with it. Now, they were certainly intimate, as people in a relationship are, and I think you're going to see evidence of the nature of that relationship and how consensual it was. It's my expectation you're also going to hear about a police report that was filed in February of 2024 by the applicant against Tectone's ex-wife. And the nature of that police report was that the applicant believed that Tectone's ex-wife was recording them in their intimate interactions with each other. You're going to hear that that was the nature of the police report, that at that point in February of 2024, a year and a half into their relationship, she never made any claims that these alleged recordings contained evidence of sexual victimization, or that they contained any evidence that Tectone had been abusing her. Further, she never made any outcry to Officer Hoffman with the Leander Police Department that she was a victim, that she was a survivor, that John had abused her sexually or in any other way. Further, you're going to hear that the applicant filed a lawsuit against John's ex-wife in Williamson County, and the nature of that lawsuit was that, centered around these alleged recordings that John's wife had made from cameras that were installed in the house when they were married. You're going to hear that in this lawsuit, the applicant details lies that had been told by John's ex-wife online, very similar to the allegations in this case. The applicant made some bold proclamations online to her followers and then followed up with this lawsuit. You're going to hear that among the lies that she details in this lawsuit that John's ex-wife was allegedly spreading online was that she was John's sex slave, that she was being groomed to be his sex slave, and she unequivocally says those statements are lies, they are not true. In fact, she characterizes those as disgusting lies. You're going to hear that that lawsuit was filed at the end of June in 2024, a month after the last details of sexual abuse she mentions in her application for a protective order. She unequivocally says those statements are lies. They're not true. Wait, who says that they weren't true? John's ex-wife says that they're not true, so she took back her statements? Or that Pinky was making up things that Tectone's ex-wife was saying and they weren't saying, I think? I don't know. We'll get it. So we keep reading. So you're going to hear, less than a month after the May 28th, May 29th incident, that she discloses in the application for a protective order. She's filing this lawsuit saying that the notion that she is a sex slave or she's been groomed to be his sex slave is a disgusting lie. You're also going to hear that she was admitted to Austin Oaks about a month after she files this lawsuit at the end of July of 2024. And you're going to see for yourself in writing that the intake staff at Austin Oaks asked her about her history of sexual victimization, and they asked specifically something. 6 months being the span that covers both of the specified allegations in the application for a protective order. And she says no. I'm guessing this is no. I'm guessing the question here is they ask specifically whether or not you've been victimized or something in the past 6 months is what I guess. And she says no. They go on to ask with more specificity, I don't know what this is, and she says something, a time period that preceded any interaction between the parties at all. You're going to be able to see that for yourself in writing. In addition to, my expectation is that you're going to see text messages, communication between the parties. It's going to give you better context on the nature of the relationship. One that was purely romantic, one that ran its course, and one that ended, unfortunately, because of the applicant. So it's my expectation at the end of all the evidence that the court is going to have no reservations denying the application for protective order, and we're going to ask you respectively to do so. The judge says, all right, thank you, Mr. Puryear. Mrs. Locke, please call your first witness. She calls her client Pinkchyu. All right, Pinky, if you'll please have a seat on the witness stand, make yourself comfortable, and I will swear you in. Witness sworn in. The judge says, go ahead. The writer, the court reporter, I think having first, been duly sworn, testified as follows. Okay, direct examination is going to be Pinky's lawyers asking her questions. How is he just going to assume what is redacted? Well, this is the defense. This is Tectone's lawyers bringing this up as evidence that favors them. And they're saying, well, they asked her something specifically, and that question that they asked spans the entire time period of all the allegations. And she says, my guess is she says no, because it wouldn't make sense to say they asked her if something happened, and then she says yes. Why would you bring that up as an... I'm guessing they're bringing this up as an argument against her. That's why I'm guessing that that's what's in here. That's the only thing that makes sense. But, okay. Okay, so direct examination is Pinky's statement. Sorry, hold on. Somebody says, but we know the order was granted, so preponderance of evidence show that these allegations likely were true. Yikes. That is not necessarily the case, okay? So I might ask for a protective order for something, and I might list on my application, I might have 10 different reasons, okay? However, it might be that a few of these things on their own would satisfy the need for a protective order, right? Maybe 9 and 10 on their own, or I say on their own together, but maybe one of these on their own is so bad that that would justify protective order. But it might be that the judge was not persuaded by any of these. So just because a protective order was granted doesn't necessarily mean every single accusation, underlying thing the judge found to be credible or was true, right? Just to say. Unless there's something very special about these protective orders that I'm not aware of, governing family law or something, but. Okay. So her lawyer asks. So direct examination is going to be her lawyer asking her questions. So this is their case to win. So she's going to be asking questions that she expects are going to bolster her side of the case. So that's what we're doing. Will you please state your name for the record? Pinkchyu. And Pinky, you are the applicant in this protective order application. Is that correct? Yes. And at the time you filed this application for protective order, were you a resident of which county? I was, Williamson County at the time. Okay. And does Tectone live in Travis County? I believe at that time he did. Okay. And at the time you were living with Tectone, were you all living in Travis County? I believe so. Okay. And so the acts that took place that you've alleged in your protective order took place in Travis County. Is that correct? Yes. All right. And you were seeking a protective order against Tectone. Is that right? Yes. Can you tell the court why? He has relentlessly harassed me and threatened to ruin my life. It's been a nightmare. I've been having to get therapy for all of the obviously sexual assault and things he's done. And I would like to move on and live my life and not have to be consistently afraid of things he's doing or threatening me. And I just want to move on and stop being scared. Okay. And in your application for protective order, you signed a declaration. Do you recall that? Yes. And then her attorney says, and judge, forgive me, I have not practiced in front of you before. I have digital and I have what do you mean? You don't get to practice your things in front of judges. This is really dumb. I have digital and I'm sorry, I shouldn't troll about any of this. I'm sorry. When she says practice, she means presented a court case or litigated in front of this particular judge. I'm sorry, I won't troll on any of these because I don't know who thinks I'm serious or not. My bad. I have not practiced in front of you before. I have digital and I have paper, and I don't know if you would, how you would like me to present these because I've got my client needs to see some of the evidence we're going to introduce. If you want me to do it electronically, but I do have a paper copy for you. The judge says paper's fine. Are you talking about the actual declaration? She says, yes, the actual declaration. The judge says, I do have that. Well, judge, I'm going to move to introduce Applicant's Exhibit 1, which is the actual application for protective order, with the declaration that is attached thereto. The judge says, all right. Any objection, Mr. Puryear? He says, no, Your Honor. All right, applicant 1 is admitted. So in court, when you are talking about things and you're referencing other things, you want to enter these as exhibits so that everybody in the court case, everybody can examine these things. In this case, particularly the judge, but also opposing counsel. They're already going to have seen all this, I would imagine, before this, but you can't just say like, oh, she said this on a statement that she signed. You would want to submit, here is the statement, by the way, that she signed. So when somebody references something, you can analyze and see for yourself they said it, and they're just like making a bunch of shit up, basically, right? I feel like you would have called or Chambers and brought this up before the hearing. They straight up might not accept evidence. I don't know how, again, this is like a state court hearing on this shit, maybe, yeah. Theoretically, so what Leon's law is saying, okay, because he's fucking suits over here, is you might have a meeting before the hearing asking how the judge prefers to receive stuff, because if you have a judge who's having a real bad day, they might say some shit like, the way that you're presenting this to me is not okay. I needed it in this format, and the fact that you didn't bring in this format means that I'm going to forbid you from submitting any of this. Not being able to submit an exhibit could be fatal to your case, because it might be that you want to reference things in these exhibits that are necessary for the testimony given by your client. So theoretically, that could be really bad. But my guess is, since this is lower state court, I'm vibing this, but my vibes is that a judge wouldn't fuck you on that hard. He would probably grant you a continuance or something, or give you time, or my guess would be that, but yeah. Okay. So now they're referring to her application, or I'm sorry, her declaration. A declaration is just basically you signed a bunch of stuff saying, hey, I'm the witness, here's what I can personally testify to, and it might be part of what you submit for a court case. These are my statements, and I agree to say that these things are all true. I would testify to these in court, and that's what she's doing now. She's testifying to the things that she is that she has written in her declaration that they submitted to the court in support of the restraining order. No objections by the other side. Pinky's lawyer. Pinky, that is the application that you, in fact, filed. Is this correct? Yes. All right. Can you turn to the page where your declaration starts, which is, I can help you out with that, page 5. Yes. All right. Let's give the court a little bit of background. What is it that you did at the time for a living when you met Mr. Robinson? At the time, I was a fairly small streamer, and I did GTA roleplay online, so like voice acting and storytelling with other streamers. What is GTA? Grand Theft Auto. Okay, and so when you say that you were a small and smaller streamer, can you quantify that for the court in terms of what's a large streamer versus a small streamer? It sounds like Pinky has been, we haven't gotten through all of this yet, but it sounds like Pinky has, I want to be careful. Your lawyer is not allowed to coach you. He's not allowed to tell you, I'm going to ask you this question, you need to respond like this. I'm going to ask you this question, you need to respond like this. But she's been given the general advice of, when you're asked a question in a deposition, in a hearing, on the witness stand, you answer concisely, and if you don't know the answer, then you say you don't know the answer. Don't fucking ramble. Don't be a yapper. So, like in my case, where Pixie, she doesn't give a fuck about the case because it's all a giant epic meme to her. She fucking yaps and rambles on a whole bunch of wild, random, retarded shit because she's just here for fun. It sounds like for Pinky, because she's taking hers seriously, is like answering concisely, answering clearly, like a lot of just like yes, no, yes, 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 or whatever, and then just giving pretty concise answers. So good for her just in terms of being a good witness so far, I think, generally speaking. Her answer is, a large streamer would have around 5,000 viewers consistently. Mine was maybe 200, but I think at the time I had less than 100,000 followers at the time. I'm sorry, 500. By 500, you mean 500,000 followers. Sorry, less than 100,000 at the time on Twitch. At the time that you met Tectone, how many, and they're called followers, is that correct? Yeah. How many did he have at the time that you met him? I think almost 1 million. All right. And what was it that Tectone did at the time that you met him? He would play Got You games. I'm guessing this was Gotcha games, but the court reporter didn't know what a Gotcha game was, so he would play Gotcha games, which is like Chinese gambling games, like with anime girls and characters like that. Okay, and is this how how did Tectone earn income at the time, to the best of your knowledge? I believe he was making $100,000 a month. How did he earn? Oh, that wasn't technically the question. It was, she thought she heard how much. And then her lawyer says, and that was from doing one in particular, if you know. He was streaming the games, and then he was also part of the very large gaming organization called One True King. They had basically all the largest streamers in Austin, and like they had a lot of control over the space. Okay, and just because, I don't know, is Austin a large market for streamers? It has a large market for some of the largest streamers. Okay, and what are some And this is it's OTK, is that correct? Yes, all right. And was Tectone a member of OTK? Yes. And you were a member of OTK? Absolutely not. Okay, why not? I was way too small, a nobody in that sense. Okay, the people that belonged to OTK, how many followers did those particular individuals have? Millions. Millions, okay. And was Tectone at that level of millions? I believe he was on his way, yes. All right, and how did you meet Tectone? I had a friend that recommended I reach out to him because we were supposed to, I guess, have some lunch thing. And he's like, he also likes anime. You should reach out. And he seems really cool. And so I reached out on Twitter and he wanted to hang out right away. And we began a friendship. Okay. And you heard opposing counsel indicate that you had pursued him and wanted to get into the relationship with Tectone. Was that accurate? No. All right. Tell the court, what is the accurate version of that, of you all getting together? I told him I did not want to date at the time. I would never date a streamer. That's why I was currently on online dating apps, because I just wanted to date a little bit outside. I tried talking to somebody in the streaming space. I wasn't really sure about it. And he then had me sit in his bathroom one time and had like a very emotional conversation and kind of used that as leverage to, convince me to try dating him. Is it said, how old was she at the start of their relationship? Do we know this? The trauma dump strat always works. Okay. And how did it go from convincing you to dating him to you moving in together with him? Nobody has an answer to this. Okay. He said, I could change your life. I'm an OTK. I have connections. You should just move in with me. You won't have to pay rent and I will help you and you try to help me. He's like, I'll get you. Here's some vitamins, and was like, I'll change your life and we'll get you better. He kept telling me that he's going to change my career. Okay. And is it a big deal belonging to OTK? Absolutely. It's huge. Okay. Just so the court understands. Why is that? Because they have pretty much control in Austin to make and break your career, whether you get invited to collaborations or get sponsorships. They also have control, and the owners own one of the largest management companies that I was also part of at the time, where he got me into it because that was another promise he said he could do. Okay, and do you know what Tectone's role in OTK was? He was a core member. He was what? A core member. What's a core? What does that mean? Well, just like the main members that represent the organization. Okay, somebody said she was 21 at the time. Okay. I thought she was significantly older. That sounds like an insult. I don't mean that. I just thought she was older. Never mind. There's no nice way to say that about a woman. I didn't mean that because she looks older. I just wasn't aware of the ages of everybody. Wait, how old is Tectone? I'll wait for my personal Discord answer because you guys are fucking retarded. Okay. Oh, wait, can I just Google this? How old is Tectone? He's 32 years old. Okay. And how old is Pinkchyu? 26? It says now she's 26, so she would have been... Is this even correct? Okay. Somebody's telling me that at the time that they started dating, she was 21 and he was 30 years old. Okay. Okay, so what was your understanding of the authority that Mr. Robinson Tectone had within OTK? Stop calling her Pinkchyu. It's Pinkchyu. It's Pinkchyu. Pinkchyu? Pinkchyu. Pinkchyu? I don't know the difference. I don't know. Pinkchyu. Oh, Pinkchyu. Oh, like Pikachu. Is that? Oh, Pinkchyu. Like Pikachu. Wait, is that really what it is? That makes so much more sense. Brother, it's not that hard. It is Pinkchyu. 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 Is there a video with her saying her name? Wait, if it's Pinkchyu, then what was I... How was I saying it wrong? What was I saying before? Pinkchyu. Pinkchyu. I'm calling her Pinky. I don't care. You guys are trolling the fuck out of me. There is no Y after pink retard. Pinkchyu. Google it. It's Pinkchyu. Oh, why did I invent another Y? Pinkchyu. Like Pichu? Like the baby version of Pink? I don't know. Don't know. Okay, Pinkchyu. Okay, Pink. I'm calling her Pink from Pinkchyu. Because her shorthand is Pinky. Oh, then I was calling her Pinky. Fuck you! Okay, what was your understanding of the authority that Tectone had within OTK? He got invited to everything. He could get you into parties. He could get you into collaborations. And then obviously he was working with Mythic Talent and could get you into Mythic Talent. And that's huge if you're wanting to get money and sponsorships. Okay, what is Mythic Talent? It is, I believe, Tectone has a part of or some type of ownership in it and another member owns it. It's just like a media management where they manage creators and give them sponsorships and collaborations. And what promises, if any, did Tectone make to you about your career if you moved in with him? He said he could come on my stream, like it will be a good dynamic, having what he explained to me, having a hot cosplay girl living in his house. And what was the arrangement that you had before you moved in with regards to rent? I just would help him with some thumbnails. So in my assumption, hold on, sorry, I got a correction. She was 24 and he was 30. She was 24 and he was 30 when they first moved in. Jesus. Okay. I would help him with some thumbnails. So in my assumption, it would just be helping him because I do graphic design and media. So I make his thumbnails and edited some things for him. Just so the court, so the record is clear. What are thumbnails? So when he posts things like YouTube videos, like I'd go in Photoshop and create a graphic design for him. Okay, and at some point, did the arrangement for the rent change? It changed after we moved in to Chestnut Ridge. Okay, and what changed? It went from make this thumbnail for me to he kept telling me to suck his dick. And at that time, he would tell me, do your job, you don't pay rent. And those are the words that I clearly remember. Okay. And how soon after? And Chestnut was in Austin, Texas. Is that right? Yes. And how soon after you moved into the Chestnut address did those activities start occurring with Tectone? Pretty right away. I don't have any inclinations of issues until we moved into that home. Okay. And how soon after you moved in did those issues begin? Pretty right away. I think once he had said that in particular, I felt disgusted. And then I told him I wanted to pay rent. And that's why soon after, towards the end of, I believe it was in the end of February, I started paying rent. I gave him $1,000. I said, I didn't like that dynamic. It made me feel disgusting. Okay. And so do you recall when you moved into that address? I believe earlier February. And that would have been of 2023, 2024, 2023. Okay. And so he made that demand. Then you said no and started paying rent. Yes. All right, and you started paying rent. Can you recall when? I believe February of 2023. Okay, and did you consistently pay rent until you moved out of the residence? Yes, it wasn't consistent. He changed the pricing a lot. What? Okay. Okay, what was the highest amount of rent you paid him? $4,000? $4,000? Yes. What were the circumstances that he raised your rent from $1,000 to $4,000? I will say up to here, it's kind of... He asked her to move in and she agreed with no understanding of any kind of romantic relationship or anything. I feel like that's a little sussy baka, but maybe, I guess. I don't know. Some girls are optimistic, but he told me that I would be moving in to the next home and started having me pay double rent when I started making more money. Were there any demands for sexual acts when that rent went up as well? I don't think you're allowed to do this. As silly as this sounds, I don't think you're allowed to. This would just be considered prostitution, right? I don't think you're allowed to exchange sex for rent, but my understanding is you're not allowed to do that. I don't know. Maybe I'll ask your mom. Got it. Can't you claim it's just a kink thing? I don't think you can engage in illegal kinks. But we have a kink for having sex right after we rob banks. I don't think you're allowed to do that. Were there any demands for sexual acts when that rent went up as well? I believe at the time it was more of an obligation. You mean the sex was an obligation? Witness nods head. Can you describe what you mean for that to the court? If your witness is not answering, sometimes you have to remind people, can you say yes or no? Not don't nod your head, but answer yes or no. I'm surprised the court reporter wrote this down and the judge or the court reporter or her attorney didn't tell her. I need you to say clearly yes or no, especially because like stuff like this could be misinterpreted or missed or whatever. You should always answer clearly. But can you describe what you mean for that to the court? Like, for example, after I had my breast surgery and I couldn't like do it for him, he would get very upset because I had to lay up straight. Am I allowed to talk about that situation? So we'll talk about that in just a second. Sorry, so hang on. You suffer from what? Anxiety, right? Yes. Okay. And you were also, is it on the spectrum? Yes. All right. And when you were taking breaths, you were trying to calm yourself down. Is that right? Yes. Okay. So let's talk about what happened when did you get your breast augmentation? Damn, that makes it sound like some fucking cyberpunk shit. I believe it was, sorry, just kidding. I believe I did it late of 2023, and then I had to get it redone in 2024, earlier in 2024. All right, and in August of 2023, was that the incident you were just talking about? Yes, it was in May of 2024. Okay, so it was after your revision. This was the revision part that this incident occurred. Okay, so in May of 2024, tell the court what happened. I was lying in my bed and my doctor told me that I had to sit up straight, like I can't lie down or to the side or anything because I still had stitches and I was still taking heavy medication. And he was getting very unruly, and upset that I couldn't give him blowjobs during my healing period. Okay, so when you said he would get upset and unruly, can you describe for the court what he would actually do? He'd be like, so you think you can suck my dick? Or he was just seemed very annoyed, I guess is a good word for it, very annoyed. And in this incident, I was laying in bed and he's like, do you think you could still suck my dick? And I was like, I told you I can't. Like the doctor said, I have to lay up straight. So I'm going to lay up straight. And I'm like, no, not right now. I'm really sorry I can't do that for you because he made me feel bad about it. What happened next? He then grabbed my shoulders and put me over his stomach and then began jerking off to my face. And pulled me over to his stomach, I'm guessing, and began jerking off on my face and told me to stick my tongue out until he came on my face. Did you consent to him doing that? No, I told him I can't. I think after that point, I think he just kind of was in shock. I think he was just kind of in shock. Like, I think there's just circumstances that I say no, and I assume that's enough to say no, that I can't. Did it cause you any physical pain, that incident? I was under a lot of medication, but I think I was just scared that it was going to mess up any of my stitches I currently had healing. Okay, had there been another incident like that before when you had some kind of cosmetic procedure and he required you to do the same action? Yes. Okay, when was that, if you can recall? Do you mind if I look? You have your affidavit. Thank you. It's been introduced into evidence if you need to review that. Okay, I can't recall. I think the last incident, I got it mixed up with this date because I read the date. Okay, so I believe this one was in May. Okay, so May of what? 2024. For this, it's okay to request, especially if it's already submitted as an exhibit, like to ask, like, can I review a thing? You should always make sure you have your dates and everything straight because if you get inconsistent on the stand or if you start fucking dates up or whatever on cross-examination, the opposing counsel could cause you to appear less credible than you should be otherwise. Especially if you're building things causally off of an event that you've gotten out of order. So be careful of that. All right, not that I'm not saying she's lying or anything. I'm just saying, just don't fuck that up. All right, and so what happened in May of 2024? I had just got my lips done. They were very swollen and painful, like you could still see the injection sites. And he asked me to suck his dick, and I said no, that it would ruin my lip injections because, if you don't let them settle, it will migrate. And he's like, oh, but it's really hot. It's really hot when they're swollen like that. They look all big and fat. And I'm like, I can't because it's going to mess up my face. And because this happened when we were lying in bed, he then put my face, he made me suck his dick. Okay, when you say that he made you, I know this is difficult, but can you describe to the court the actions he took to force you to do so? He grabbed the back of my head and slowly put it to his dick, and then he told me to open my mouth and suck his dick. Okay. And he also made public comments about this as well, that I believe is in my timeline. Okay, we'll get to the public comments in a minute, but did you end up having issues with your lip filler after that incident? Yes, so because he did that, it did migrate, and I complained to him multiple times afterwards that what he did caused the migration, and he's like, oh, it doesn't look that bad. It's not a big deal, is what he would say. And what did you have to have done, if anything, to correct that? I had to get them dissolved and then fixed. Let's talk a little bit about the relationship. Did you have your own room at the residence? I was paying for one room, and because the other roommate, he would complain that the other roommate wasn't paying rent all the time. So he told me that I offered to pay for another room to help pay for the rent because he complained about money a lot. He told me, so I offered to pay for another room to help pay for the rent because he complained about money a lot. Okay, so did you all, I guess, cohabitate in the same bedroom? Yes, he had me sleep with him a lot because he always mentioned that with his schizophrenia, he was afraid to sleep alone. and I feel guilty and bad if I didn't. Okay, and he has admitted to you that he's schizophrenic. Yes, and publicly. Okay, he's actually done so on his streams, right? Yes. Do you know, if at all, what medications he takes for his schizophrenia? He said he used to take them when he was younger, and he didn't like that. I guess it didn't make him himself, so doesn't take them anymore. How common is it that you get schizophrenia as a child? Prevalence of approximately 1 in 40,000. This is a severe form of the illness with gradual onset and poor outcome. If you were diagnosed with schizophrenia as a child, just based on this, my feeling is by the time you're in your 20s and 30s, you would it would be very, very, very bad. But that's an interesting claim. Okay, Jesus. Maybe he meant teenager. I mean, even as a teenager, I feel like it would progress quite poorly by the time you're in your 20s and 30s. Average age schizophrenia onset. This says onset tends to be earlier in males, late teens to early 20s, which would track with if you said freshman in college. But damn, by the time you're 30, if you don't medicate, I wonder, average schizophrenia disease, what would it be, prognosis or progression? Like what happens on average if you don't, I don't know what the fuck this is. Where's my Mayo Clinic bullshit? Typically diagnosed in late teens to early 30s, and tends to emerge earlier in males than females. It's one of the top 15 leading causes of disability worldwide. Increased risk of premature mortality. Average life loss for individuals with schizophrenia is 28.5 years of life loss. Jesus. Okay, well. Do you think it's possible he's lying about schizophrenia and using it as an abuse tactic? It's possible, but again, this is just her testimony so far. I don't know what their response is going to be to anything yet, or what they'll say, what she'll say under cross-examination. We'll see. And are you aware, and this goes back when you were living together, was he taking any medications that you're aware of for schizophrenia? No. Okay, did you ever see him have any schizophrenic episodes? Many. Okay, and can you describe for the court what it was like when he would have a schizophrenic episode? He mentioned one time he was driving with his friend Jimmy and he almost crashed his car because he saw somebody behind him, I guess, speaking to him because he sees people walking around, as well as he would get scared because he said he'd see versions of myself giving myself suicide around the house, committing suicide around the house, versions of you. Yes, and that my face would be melting when he looked at me and it would scare him. Okay, and he never went and sought psychiatric care to the best of your knowledge? No, I tried to tell him many times, specifically because he told me he almost crashed his car and had a lot of these issues where he was consistently afraid or paranoid. Did you all in your relationship ever have traditional, like, vaginal sex? No. Okay, why not? He told me because of trauma. Then he mentioned his ex-wife, but I don't know if I can go into that. Well, there's an NDA related to that particular lawsuit, right? Yes, he had her sign an NDA. Okay, so we won't talk about the details of that. But what else did he tell you about why he did not engage in traditional vaginal intercourse with you? He said his sister, Jesus, okay? He said his sister molested him when he was younger, and he consistently told me that he was disgusted by vaginas. Okay, and did you all ever, like, kiss like a normal relationship? We did hug a lot, but he was not a fan of kissing because he said he had he would get a lot of saliva in his mouth. So consistently, anyone who knows him knows that he spits all the time when he walks around. which, by the way, if you're a spitter person, that's just fucking disgusting. But Jesus, I don't know, people who do that is fucking gross. What did he ask you to do instead of the traditional kissing? Multiple times he would ask if he could spit in my mouth. And what was your response to him? No, I personally have a disgust for like spit stuff myself. All right. And so were there any interactions where he was physical with you to engage in relation that would make you happy? Never. And so did he ever have his hands ever touched you physically under your pants? Not under my pants, no. Okay, and I'm sorry to be explicit, but his hands never touched your vagina. Is that right? No. Okay, did his penis ever touch your vagina? Never. And so the only activity was the blowjobs, was me giving him blowjobs. How often would he record you during the blowjobs? I would say about 40% of the time. Okay, and did he do so with your consent? I could say maybe 2 or 3 times where he asked, and then it got to the point where he just didn't ask. There were times where I didn't like it, and I would squint my eyes, and he would get upset and delete the recording, and then start the recording, and he's like, I need you to open your eyes, make noises, stick your tongue out. I don't want to do it, but like make a huffing, like moaning noises, and look at the camera, and look like you like it, is what he would tell me when he would re-record again. And did he do anything else with that, did he do anything else with regards to the oral sex with him that you disliked? I really didn't like cum, and so much with the spit thing, just personal trauma, I don't like it, or I didn't like it. And so he would always want to try, like his goal, I guess, was to get me to swallow his cum a lot. There's a lot, a lot of the times I would just gag a lot. Did you tell him no? I would just tell him I really don't like it, and he wanted to make it his goal to get me to do it. And how did he convey that to you, that he wanted that to, that was his goal? He's like, oh, you just got to keep doing it and you'll get used to it. Did he ever make you write anything on your face? Yes. Can you tell the court about that? He told me to go into the bathroom, and I believe that it was a derogatory word of slut on my forehead and come here with an arrow pointing to my mouth. And he said that if I did that he'll have a normal sexual relationship and we'll have normal sex if I did that. And I guess like in my head, I thought if I did that, we'd just have a normal relationship. Sorry. It sounds like she's probably crying or getting emotional here. It's okay. Take a breath. She said, I'm sorry. It's okay. I'm sorry. And then her attorney's requesting a break. Break, please. Yes, let's take a recess. Thank you, judge. Brief recess. That judge says, let's go back on the record in this cause. Please proceed. Mrs. Locke. Didn't Tectone flame Destiny for being a Coomer Gremlin or something like that too? How are all these guys always projecting so hard? True. Even with Turkey Tom, even if that girl was probably asking for a lot of the hardcore sex, it seems like these guys, true, Back on record, direct examination, meaning it's her own attorney asking her questions, going back to questioning them. So he told you that that you all could have a normal relationship if you did that particular act. Is that right? Yes. And at any point, did you all have any normal relationship after that? No. Okay. At what point did the relationship start to unravel or get close to ending? We had a talk and mutually decided to end it more, I believe, on his side. And then soon after, we had a talk and got back together, and then I ended the relationship later on. All right, and you all had discussions. He would address your mental health, right? Yes, he always said that whenever I had complaints about how he was treating me or anything, he said because I'm autistic, my version of reality is not like normal people, and that he would have to explain to me what was really going on. And you all had a journal, is that right? Or you had a journal? I kind of just started one. He had me write a list of things he said that were wrong with me that he said I needed to give a psychiatrist. And then he later graded me on things he thinks I need to work on. And what did he say that you needed to go see a psychiatrist for? That my memory recollection was incorrect. I believe I wrote it in the journal. I can't remember by specific. These are unironic two statements together. I think that this is a good way to problem solve in a relationship if you involve a third party. I think that writing down problems that you want to talk about and things to work on is fine, but then you need a third party to moderate the conversations or something afterwards. Otherwise, this is a very one-sided dynamic Like if you're having to write things down and then debate with your partner over your feelings on things, especially if you're, here's like, I have to wield advice responsibly. If you're in a dynamic where you consistently feel uncomfortable, and when you present that dynamic to your partner, they're doing things that makes you feel bad for bringing it up, you have to find a way to get a third party to moderate those conversations. Like there is a world where you're being unreasonable and you're bringing up stuff that isn't fair. So maybe your recollection of events is not true and then you're attacking your partner over it. That's possible. But there's also a world where your feelings are incredibly fair, but because you don't have a third party to back you up on it, your partner, who might be more conversationally, fluid or more manipulatively adept, might be able to convince you out of those feelings. So if you consistently try to present a problem in a relationship and you feel like you're always walking away feeling bad, and this is so important, feeling bad doesn't have to mean that you feel like that you know that, or I'm sorry, feeling bad doesn't mean that you feel bad all the time because they did something wrong. You could just be feeling bad in general, because one of the things that manipulative people are really good at doing, I'm not necessarily saying that happened here, although it kind of sounds like it, is making it feel like it's always your fault, right? So let's say that I have a weaker personality, or I'm a little bit more submissive interpersonally, and I'm with a partner who's much more domineering interpersonally. If I present an issue where it's like, hey, I noticed that when we are having a sexual interaction, you're always like very like aggressive with me, and I don't appreciate that. And there's like the level 1 upsettedness where they can say like, well, I don't give a fuck what you think or whatever. And you're like, oh, well, I feel bad about that. And it's obvious that you feel bad because they're being inconsiderate, right? And it's like, okay, that's an easy one to spot. But it could be that, every time you bring this up, they say things like, okay, well, when I start doing it, you never say anything in the moment. It seems like you enjoy it then. Most of the time you manage to come when we're having sex and when we're messing around. So it seems like you enjoy it. And I feel like you're just bringing this up now because you're punishing me for some unrelated issue. Like you're bringing this up now, and then you also got mad at me earlier for not doing the dishes. Are you just trying to use our sex life and hold it hostage to not give me things that I want that Like when you start getting into a ton of conversations and then you walk away feeling like, oh, fuck, like I'm the bad guy. And even when I brought up a thing that made me feel bad, I'm still the bad guy. Those are situations that in my opinion, you really, really, really need a third party to step in and moderate, because you might be getting unbelievably fucking mind fucked because you have a conflict of interest there, right? Technically in all interpersonal disputes, there's a conflict of interest. Well, it's not conflict. It's just one party representing their interest against yours sometimes, right? And ideally you're both representing your interest for the positivity of the relationship, but especially in conflicts, one side can overplay their interest in their own stuff at the detriment to the other party, to the girlfriend or boyfriend of the relationship. But just say like having third parties moderate your disagreements as couples, I think it can be very healthy sometimes. Yeah. Okay. Especially when you're in situations where the other party is telling you that you can't trust your recollection of events, or you can't trust your own feelings on things. Just saying. Okay. Okay, I sent you a copy of this, but this is the actual journal. And then this is Pink's attorney. Pinky's attorney by Mrs. Locke. Would seeing the journal help you refresh your recollection? She says yes. Judge, may I approach? Judge says you may. Thank you. And then her attorney says, hang on, that's in fact the journal that he wrote in. Is that right? That he wrote in or that she wrote in? Pinky says yes. All right, just review it to refresh your recollection first. I'm actually not going to introduce the journal. Okay, I see it. Okay, I'm not going to introduce the journal. So she's using this to refresh her own recollection, and this isn't a prior statement that she's made, alleging that this statement was made in a journal. So they don't technically have to, I don't think, submit this as evidence, because it's not like they're saying, well, I wrote this in my journal to prove this point. Just ideally, I think this is just refreshing her own recollection. I don't think she needs to submit this as an evidence or an exhibit or anything. I think it makes us okay here, I believe, right? Now, if they were to try to say something like, I know for a fact that this is wrong, and I know it so well because I even wrote this in my journal 2 years ago, in that case, you would have to submit it as evidence, because then the other side has a right to examine it, cross-examine it, whatever. But, okay. All right. Now, do you remember what it was that he was complaining with regards to you and your mental health? She says, he said I was immature, that my memory recollection was incorrect, that my phrasing, that, he would say things and then I would phrase it incorrectly, that I lacked communication skills, that I was depressed and dooming a lot, that I wasn't a positive person, I didn't take accountability, I was not independent enough, that I was paranoid, and that I had no emotional control. Did he accuse you of being schizophrenic? It felt like it at times. I don't know. Okay. And what are your actual, sitting here today, your mental health diagnoses? I'm autistic as well as have anxiety disorder. Okay, you've not been diagnosed with bipolar disorder. I was misdiagnosed and correctly diagnosed with autism, and I was diagnosed with autism twice by psychiatrists, and medical professionals. Okay, so they replaced the bipolar with the autism spectrum disorder. That was a primary care doctor. He just gave me I think this is what you might have, but it wasn't a psychiatrist. And then I went to see a psychiatrist and I got correctly diagnosed. And there's been discussion of a hospitalization that you had. Do you recall that? Yes. All right. And you went to Austin Oaks, right? Yes. Did you do so voluntarily or were you first forced to go? I think because of the situation I was in, I just wanted to get out. I think because of the list he gave me, I went to an online doctor, told them that the list of things that he told me to tell her, and she gave me medications that made me just shake because obviously I'm not schizophrenic or anything, so it doesn't work for me, and I just needed to get out. I decided to get out of the house. When you did that online appointment, was he there with you when you did the online appointment? No, but he had me write the list of what I needed to tell her. Okay, and what medications did that doctor prescribe? I believe it was some medication. And did that work for you in any way? No, I tried to tell him, oh, it's great, it's fine, but I would tell my assistant, I was like, this is making me shake. I don't like the way this makes me feel. Are you currently taking it? Absolutely not. Okay, and so the Austin Oaks, where did you go after? Let me back up a little bit. How long were you at Austin Oaks? 3 days. Okay, and what were your discharge instructions? So 3 days, 72 hours. This sounds like a psych hold. I think there is a, you call it 5150 or Brady Act, I think in California, but basically if you're a threat to yourself or others, they forcibly lock you out basically for 3 days in a psychiatric place until you're deemed not a threat. That might not be this though, I don't know. But she asked earlier, this is not clear. I don't know what the answer is here. Oh, I'm sorry. What did I say? Did I say Brady Act? Baker Act. Sorry. Same thing. Whatever. Not really, but I don't know if this was voluntary or not. It sounds like this was voluntary, but okay. She was there for 3 days. Okay, and what were your discharge instructions? Just blank, blank, blank. I can't remember what it was, but instead I decided to go ahead and see a therapist. Okay, and did you actually have any acts of did you intentionally self-harm or no? So what was the reason you went? I just needed to get out of the house. So it sounds like this was voluntary. It doesn't sound like she was involuntarily committed. I just needed to get out of the house. I think at the time I was just confused. I knew something in my gut was wrong, like how I was being treated, but he was telling me otherwise. And I was just confused. And I called my sister. I said, I just need to get out. I just need to see somebody. I need to get out of this place. I calmly packed up my clothes, told my roommate, hey, I'm going to be leaving. I'm not feeling good. And then my sister drove me. I went there. They said, hey, there's nothing we can really do. You're fine. But if you want, you can admit yourself to get evaluated. Okay. So did you self-admit? Yes. And when you were discharged or left Austin Oaks, did you get back into that same residence with Tectone? No. Okay. Where did you go after that? I went to my mom's. I did go to his house to collect items that when he wasn't there. And that's when I confided in at the time, his roommate that I guess that was going to be moving in. I said, I'm afraid of him. I'm really scared. I'm going to go ahead and stay at my mom's because I can't be here. And you heard opposing counsel indicate in opening that you didn't make any reference to Tectone being abusive when you went to Austin Oaks. Do you recall him saying that? I'm sorry, I'll rephrase. Do you recall opposing counsel, and opposing counsel means the other attorney for the other party, in his opening statements making comments that you didn't mention anything wrong with Tectone when you were at Austin Oaks? Yes, I remember. As a lawyer, you would probably just say to your client, the other lawyers. I don't think most non-lawyer people would ever use OC or opposing counsel, jargony stuff. Pretty mean, bullying. Yes, I remember. Okay. When was it that you first realized that what was going on was what is sexual assault? It was after I moved my stuff out and I talked to an online friend and I felt safe enough to speak to someone about it, the events that had occurred. Okay, and have you had contact with law enforcement regarding these allegations? Yes. When did you make contact with law enforcement? Do you mind if I look? You can look at your affidavit. Judge, may I retrieve the journal? You may. I believe it was around January of 2025. I do believe it was early the next year. I just can't remember the exact date of when we went into the, and then her lawyer, okay, but did you file a criminal complaint? Yes, I filed a police report. And what is the current status of that? Because of the harassment, I had to suspend it. You can suspend a police report? Interesting. Okay. Okay, they wanted, what did law enforcement want you to do with regards to a phone call to Tectone? Or actually, I guess maybe you could for domestic violence stuff. Maybe. A preliminary call. Okay, and was it a pretext call? Yes. All right, and what was your understanding of what you were supposed to do on the phone call? Call him and get him to talk about the things he did to me. Oh, this was like they were wired in basically to the phone call? Ooh. Texas is a one-party consent state. I wonder if the cops can get, but the cops can probably get a wiretap order if they really want. But in a one-party consent state, you wouldn't even have to, I don't think, right? Even for sex? No, this is just for, like, recorded conversations, I think. Okay. All right, and were you able to do so? No, because he was threatening me and harassing me publicly and I was scared. Okay, we'll get to that in a second, but did you not follow along with what law enforcement wanted you to do? No, I did what was recommended. I did what was recommended by the counselor that was there with me. All right, and so around the same time, did Tectone start posting on, what was it? Is it Twitter or is it X? I don't know. It was Twitch, YouTube, and Twitter. He did it on all three. And starting in January of 2025, what did he start doing with regards to the online platforms? He started before then. He started, I believe around November. He started the threats in 2024. And what kind of threats was he making online? I have a timeline of everything. Okay. But it was mainly, I'm going to sue you. He's also made threats that he's going to ruin me, that everybody was going to know the truth, that he was coming after me, that there were explicit material that he shared with multiple people and that he will post them online if I don't retract statements. And it is almost 200 pages of it. And you actually asked him to do, when you first broke up, what did you actually ask him to do with regards to the videos? One thing, don't ever take, obviously no lawyer is going to take my advice and you shouldn't, but like, this is your time under direct examination. This is your time to make the strongest positive statements that you can about your side of all the evidence that's going to be brought up. If she made a tweet about sexual abuse and Tectone was responding to it, my hope would be that your lawyer is going to ask you about the statements that you made so that she can build a case for as to why you made the statements, his response to it, and why they're unhinged, rather than just presenting his response and letting opposing counsel take a shot under cross-examination of getting you to admit to making those statements, because it's going to be done under the framing that they want. Maybe there's a legal reason why what I'm saying would be a bad strategy, or maybe there's a reason why they wouldn't do that. But I'm surprised that as part of her questioning here, why her own lawyer wouldn't build the story around why she made statements about sexual abuse or assault online, and why would she give the opposing counsel the ability to asymmetrically take a shot at introducing that to the judge. But maybe there's a reason why, I'm not sure, I don't know. Or maybe they will later on, who knows, we'll see. Because even here she says, if I don't retract statements, well, what statements did you make? You know, because I would imagine for sure that opposing counsel is going to bring that up under cross-examination. But I don't know. Okay, so what did you ask him to do with regards to those videos? I asked him multiple times in multiple circumstances, please delete any sexual footage you have of me, because I knew that some of it was not consensual. And he would make collages of my videos and things like that, and it was very disturbing. I didn't want him to have access to them. Sitting here today, do you know if he's deleted all those videos? I do not know. He's told me that he would, and then the last time I requested, he just did not respond. Okay, so sitting here today, you have no idea if he still has those videos in his possession. Yes, I'm not aware if he does or not. Are you concerned about what he will do if he has those? Yes, and what are your concerns? He'll either post them publicly, continue to share them with more people, as he had stated, and possibly I don't want that. I don't think anyone wants that. Hold on, just saying if Leon responded. Oh, motherfucker. No, okay. Has he threatened you with putting that out there? Yes. Okay, how has he done so? I don't have the exact verbiage. It is in the timeline of what he said in his words. Okay, did you have to contact an attorney in early 2025 with regards to what was going on online? Yes, it had just gotten very overwhelming because no one wanted to associate with me because he was attacking me. He had attacked them as well. Okay. And I was becoming very isolated. I kind of had to rebuild my friend group with my family. Sorry, what was the question? That's okay. What was going on online? What was going on online that gave you to the point where you had to hire an attorney back in early 2025? Oh, yes. Even after going to the police, he still would not stop harassing me. And I had an attorney send him a cease and desist telling him that I had gone to the police and he needs to leave me alone. Did that stop him? No, in fact, he went publicly and laughed about it and said, she sent me a cease and desist for defaming her, but I'm going to keep defaming her. If he really said this, if there's really videos of him saying this, is not good, very bad, right? The whole point of like a cease and desist is you're showing the court beforehand, like, hey, listen, I'm only here in front of you, judge, because I tried everything I could outside of court to remedy the situation, and it's not working. I need relief that only a court can grant me now. And if he's like laughing off cease and desists, it's a stronger argument for I need a protective order. I need something greater. He clearly doesn't give a fuck, right? Kafka said, is this a hearing or in front of a jury? So this is a hearing over this protective order, but I feel like, I don't know how this works exactly, but like the whole court case is basically over this protective order. Like she just wants an injunction basically against him. But I don't think this is the type of thing, for whatever reason, it doesn't go to trial. Like the judge just approves or denies this motion for a protective order. So I don't even know if this is considered a bench trial or if it's just a judge ruling on motions. I don't know how that works or what that's considered technically. Jesus. Okay, and that was February 6th of 2025. He posted a live stream on Twitch. I'm not sure of the exact date that he did that. Okay, has he made threats about going nuclear when the legal situation between you and he ends? Yes, and I believe it was the time he was like showing his guns and things. Oh no, if he did these things in conjunction, not good. Okay, and in fact, he's indicated on social media that he's schizophrenic and is strapping, referring to weapons. Is that correct? Yes. Tell the court your concerns about his use of, or I'm sorry, his possession of firearms. I'm afraid that if he does, obviously, with the threats, he gets so upset that he will try to do something to me, especially because I do go to conventions and public things, or if like he has an episode or anything and is upset enough. And you filed this on the protective order. So you first contacted an attorney in January, went to the police in January of 2025. Why is it that you filed a protective order application in August of 2025? Well, first, it was mainly just this is what I mean. This is good. You get ahead of these things because you know that the other guy's going to ask this on cross-examination. So I don't know why they didn't for the statement she made online, but again, maybe they'll get to it, or maybe they just didn't think it was important to. I don't know. Well, first, it was mainly just dealing with the police and the preliminary call and trying to get that set up and whether that was the right move to do for my safety. And so it kind of just kept getting pushed between the police and then his threats. And he in this lawsuit, and then she stops. I'll ask the court to take judicial notice of the filing of the application for protective order, which was August 21st of 2025. Yes, the court will do so. And then she says, may I approach the witness? You may, thank you. I'm going to show you what we've marked as applicant's Exhibit 7. Are you able to identify that? Yes. Okay, without telling what's in it yet, the statement's in it. What is it? A tweet from Tectone, Mr. Robinson. Okay, what does Tectone go by on social media? What does Mr. Robinson go by Tectone? And that's, can you spell it for the court reporter, please? Spell it, yes, for the court reporter. Tectone, Tectone. All right, and what is it that you go by online? Pinkchyu. Can you please spell that for the court reporter? Pinkchyu. All right, and that is a true and accurate copy of the message that he put out on his social media on August 25th of 2025. Is that correct? Yes. And when you read this, did you note this related to you? Yes. And how did you know that was related to you? Okay, I don't know if they will or not, but now you can start to see some of the things you see like in TV shows. When they say things like, can you read that out for the court? it seems like a dramatic thing, like read it for the court so that everybody can be astounded. But it's also nice just for people that have transcripts. Can you please read what you're looking at for the court? Also so that the court reporter can write it down so now that we would know what's being referenced. There might be exhibits attached to this transcript. I don't know. I'm checking my DMs and some people send me stuff. Maybe we'll look at them after. But this is why it's nice to like, can you read this aloud for us so the court reporter and people reading your transcript can hear. But so I don't know if they will or not, but okay. How do you know that this is related to you? This was many of his multiple times where he's named me or not named me, or it was times where I sent the cease and desist or have gone to the police and he would make statements like this. All right, and this is a true and correct copy of this. You've not changed or modified it in any way. Is that correct? Yes. Judge, I move to introduce applicants 7. Any objection? Mr. Puryear. Mr. Puryear says, relevance, Your Honor. This could be about anything. I don't understand what the relevance this has to the proceedings in front of the court. I don't think that those dots have been connected sufficiently, but that would be my objection. The judge says your objection is relevance. It's overruled. Applicant 7 is admitted. She says, thank you. I don't know all the objections. I'm doing a super layman's guess here, but when the objection is relevance, you're saying that, like, is the material that's being introduced, is this necessary does it go to any of the causes of action or claims that are being made here? So if I wanted to introduce into evidence, like, here's a tweet where this guy said, I'm a big fucking loser and everybody should think I'm a big fucking loser because I like gotcha games, you could say, well, objection, relevance, like, this doesn't go to prove anything related to this case, like, this isn't needed. But so when the judge overrules the objection, he's saying that I believe your objection is unfounded. This can be submitted for the court to evaluate as part of this case, basically. Kafka says relevance means they're saying the evidence is more prejudicial than probative. Prejudicial meaning it's giving you some impression of probably the opposing party that's negative, that is not relevant to the case, and probative meaning it doesn't establish anything that both sides can question about or use to determine how true a claim is. I think basically, right, is when you say something is probative is what you mean, I think. Maybe close enough, maybe. Okay, thank you. She says, and then her attorney asks, what was it that Tectone published 4 days after this application for protective order was filed? I'm not sure of the dates correctly. I'm sorry, what are the dates? Can you zoom in? Do you say, I'm sorry, August 22nd, 2025, and this was the day after the application was filed? Is that right? I believe so. Okay, and you've received extensions of this ex parte protective order that was granted back in August. Is that right? Yes. All right. Judge, may I approach the witness? Of course. She says, Pinkchyu, I'm going to show you what's been marked as applicants 9, 10, 11, 12, and 13. Will you look at those, please? So these are my guesses on the initial application for a protective order. On the initial application for protective order, you have these exhibits that you attach to show as proof for the claims you're making that you're referencing in your protective order, and these are just the different exhibits that were put as part of that. Wait, somebody in YouTube chat said, no, relevance is not the same as more prejudicial than probative. Leon's Law says, relevance pretty much always loses. Okay. Okay. Okay, let's start with, those are all, like the last exhibit, Exhibit 7, those are all various screenshots of Tectone posting. Is that correct? Yes, all right. And just to lay the foundation, you've not changed or modified these in any way. Is that correct? Yes. These are true and correct copies of the social media posts that Tectone, aka Mr. Robinson, published. Is that correct? Yes. And 9 is from September 16th, 2025. Is that correct? Yes. All right. And there's an extension of this protective order signed back in on September 3rd. Is that correct? Yes. All right. And this paperwork was extended until December 3rd of 2025. Is that correct? I believe so. Yes. So he's posting things past even when the protective order was granted. Okay. Not good, depending on what he's posting. Judge, this is her attorney to the judge. Judge, I would ask the court to take judicial notice. I'm sorry, I apologize for not standing, Judge. The court take judicial notice of the agreed order for extension of temporary expedited protective order. I've marked it and will move to introduce it as applicant's exhibit 3. Any objection, Mr. Puryear? No, Your Honor. All right, applicant's 3 is admitted. May I approach 2 with the court reporter? You may. Let me lay the foundation on all of them. So that was a true and correct copy of the post that he put on September 16th of 2025. Yes. And did you believe this one to be about you? Yes. Why? Anytime there was an extension of something, he had something to say. Okay, Judge, I move to introduce applicants exhibit 9. Are you moving to introduce 9 through 13 or just 9? I want to lay the foundation for 9, so I'm just going to one by one, Judge. I'm sorry. No problem, Mr. Puryear. No objection, Your Honor. 9 is admitted. Can you go to 10, please? And 10 was posted on September 22nd, 2025. Yes. All right. And you have not changed or modified this in any way. Is that correct? No. It's a true and correct copy of the post that Tectone, aka John, Mr. Robinson, posted on or about that date. And this was related to something to you. All right. You believe to be. Okay. Introducing, blah, blah, blah. What's the, people keep asking me the update just came out. I don't know. I have no idea what that means. I don't know what it means. I think it means I win. That's what it means. It looked like it said something was rescheduled or canceled for a hearing or something. I have no idea if it's a mistake or what it's posted for, or it says order, setting, resetting, canceling a hearing. I don't know, but that's it. I have no idea. Oh, paperless order, time change only, resetting calendar call. Calendar call is reset in this matter for Tuesday, May 12th at 8:30 a.m. in courtroom 11-4, courthouse before Judge Jacqueline Bernard. This hearing is reset due to a scheduling conflict. I have no idea. Maybe for if there's stuff on right when you file a court case, there's a schedule that's released in advance that gives you like dates for major events. It might be that there's some other date that would conflict with, I don't know if that was supposed to be the trial date. So they're having, they're resetting that because there's a conflict that popped up with the main judge. That's my guess for what that is. So they're just rescheduling that, is my guess. Okay. So let's go to A11. What does Tectone tell to his followers on September 23rd, 2025? If you think $10,000 is a lot to start VTubing, you should see how much women spend on plastic surgery to start OnlyFans or OF. OF stands for OnlyFans? Yes. Do you have an OnlyFans account? Yes. When did you create your OnlyFans account? I believe towards the end of December of 2024. All right. So John knew, or I'm sorry, Tectone knew you had an OnlyFans account. He encouraged me to make one. Okay. But you're not doing any nudity on your account. Is that correct? I do not do full nudity. All right. And he encouraged you to do so. I feel like the attorney here should explain to the court what an OnlyFans account is, or establish that. Maybe she's just expecting the judge to get it. I feel like she should be establishing this. Like, can you tell the court, like, what is OnlyFans? What is an OnlyFans account? What is it? Because I don't know if the judge is going to understand what any of this even has to do with or whatever. But okay. We agreed that I did not. Oh wait. All right, and he encouraged you to do that. We agreed that I did not do full nudity. Okay, but he is the one who encouraged you to make an OnlyFans. I had a Fansly account at the time. OnlyFans is more stigmatized and kind of can hurt your career more than just having a Fansly. Okay, and do you know what the reference to the 10K to starting YouTubing is? What that reference is to make a VTuber model. Yeah, there's like a lot of stuff. Anytime you're introducing stuff into the record or to the court or whatever, like you should be explaining a little bit, like this is what this is, this is why it's relevant. Because even though we all know, obviously, as huge VTuber and OnlyFans connoisseurs, we might know why it's relevant or why this matters. The judge might have absolutely no clue, and likely has no clue what's going on with any of this, To make a VTuber model, I'm so sorry, I'm just a lawyer. To make a graphic for your streaming. Oh, okay. Let's go to 12. What does Tectone post to his audience again around the same date? September 2025. Can you read that, please? I made a post about this earlier, and I'm going to need you to say it again. Oh, is this what Tectone posts? Do not date crazy chicks. No, you will not fix them. No, it will not be worth it. Yes, it's fucking stupid. It's like inviting a rabid dog into your house. Sure, they might be cute, but that thing got rabies and going to kill your ass. You won't have a partner, you'll have a liability. And if you don't stoop to their delusions, they'll turn against you and make you their next target. Find yourself a nice girl or a guy that you can communicate effectively with, not an adult with a mind of a deranged psychopath. Was there any doubt who this referred to in your mind? It was me. Okay, and how did you know it was you? He said multiple times with my name, specifically stating my name on stream and publicly that I was crazy. Like, wouldn't you have to... I don't know if there'd be an objection here. Wouldn't you need to submit that? Like, why would you just take this for granted? Shouldn't the other side like objection and... I don't know if this would be... If you would say hearsay, or shouldn't you have to submit evidence of these claims? Maybe this will come up in cross. Maybe it fucking doesn't matter because it's a state court. Maybe it's not that important. I don't know. I don't know. What the fuck do I know? Who knows? If my lawyer was there and somebody was making claims about shit I said on stream, I want you to submit those. Show me exactly what I said, motherfucker. Don't just say what I said. If you heard it, if there's evidence of it, then submit that directly, you know? But okay. I don't know. All right, let's go to 13. Are these the types of messages that you found to be harassing? Yes. Okay, and were these the types of messages that your attorney requested he stop doing in the cease and desist? Yes. All right, let's go to A13. I wonder how much time she's given between all these exhibits. Like, is the judge, like, are you asking questions while the judge is reading this? I feel like you should be reading these statements. Like, let the judge absorb it. Like, these are the big statements that you're submitting into evidence, ruling for your protective order. Like, read them for the judge. Let him absorb all of these. Maybe she's taking a lot of time and it just doesn't show up. Maybe she's like, okay, let's go to 13. And then she waits like 30 seconds for the judge. Although I feel like the judge would be nodding or saying something, but I don't know. It feels weird to just be skimming through these so quickly. But I don't know. Maybe I'm retarded. Maybe. Why are you trash talking state court? Isn't like 90% of court state court? I'm not trash talking. I'm just saying that like things might be a little bit less formal in state court. I've heard that a lot than they are in federal court. Not necessarily trash talking. They're just like less, like a little bit less formal. That's all I'm saying. Yeah. Tell me, do you do a little bit of like anime? Is that what you do? Like you dress up as cosplay as anime characters? Yes. Okay. So back in October 3rd of 2025, so 2 months after the protective order has been filed and the ex parte has been granted, what did he post on his socials? So now they're reading the tweets and stuff. This is good. Maybe the other stuff wasn't readable. I don't know. Whatever. Yes. Okay. So back in 2 months. Okay. She says, do not put your dick in crazy. It's hot in anime, stupid as fuck in real life. What else did he say about mental illness? You can't fix a mental illness, bro. You can medicate it, but that's a crapshoot. Get someone who you don't need to fix much easier. All right. Did you have any doubt these were about you? No, I had no doubt it was about me. Okay. And how did your fans, if at all, because I don't know how this works, how did you learn that he was talking about you on social media? People in my community would let me know and tag me and at me. My friends, people in the space, because it did affect my livelihood and my consistent life, because people who worked with me would be technically associated with somebody he's consistently attacking, and they were afraid that he would also attack them as well. All right, and let's go to 13. I'm sorry, 14 is correct. I don't believe I have that page, but I can see it on the screen. I'm sorry, that will be these ones, 15 through 21, I think. May I approach judge? You may. I'm going to show you applicants' exhibits 15, 16, 17, 19, 20, 21. Other opposing counsel, no objection to these, Your Honor. No objection, all right. Applicants 15 through 21 are admitted. Sounds like she's presenting these to Pink to learn, or I'm sorry, to read from. Admission by party opponent is an exception to rule, is an exception to the rule against hearsay. Admission by party opponent is an exception to rule against hearsay. Does that include like public statements, or does that just include things that you've interpersonally witnessed? I don't know the answer to that. Okay. And this is Robertson on applicants 15, actually referring to allegations. Is that correct? I believe so, yes. All right. And what does he say? They're going to hate what I found today. Your loss is now even more inevitable. Now I wait. Okay. And when you see these messages that he posts like this, how did you interpret them? Like, how did it make you feel? Like he's coming after me? Okay. And then let's go to 16. So the same month, October 2025. So shortly after the protective order was filed, what does Tectone post yet again about this? Another OnlyFans woman lying about rape, then just moves on. No damage done to them. Ruin a man's life for 3 years. Why is this so common? And did you believe that this, what was also related to you in a way? Yes. Okay. And why did you believe so? What he does is he basically trains his community into hating OnlyFans or women, or also migrants and things like that. I'm half Mexican, and just things to hate about women and women that have OnlyFans. So when he does attack me, that they're more angry towards me. Now, have you had some of his fans come after you in these platforms? Oh, absolutely. You really can't object to any of this? You're just allowed to just say all of this? As long as it's a statement by your party's opponent, it's fair game. Okay. I can understand it being admitted. I just don't know why you wouldn't produce like a... Or no, never mind. I understand. Because my objection earlier wasn't that it was... My objection was that it was admitted. The other side should object. But you're saying that it would be an exception, so it wouldn't be. Okay, that makes sense, I guess. Is this not like prejudicial, or what's the relevance here? Well, I mean, I guess no, not necessarily. Oh, fuck it, no. Okay, whatever. He's also racist, Your Honor. Based. Okay. Now, if you had some of his fans come after you in these platforms, oh, absolutely. Can you explain that to the court, please? I've had people make threats, YouTube videos, calling me a liar, a whore, threatened to want to kill me. I believe I've also had a DM. Somebody threatened to rape me. Basically, it had gotten to the point where I didn't even go to TwitchCon because I was afraid maybe one of his fans might try to physically hurt me. This is stuff, though, because now that's not a party to the case. This is stuff you should have to produce evidence for, right? That the other side could say... Or no, actually, no, because you're testifying that you personally witnessed this, right? So technically you could say that, and the other people aren't like on trial for anything, so I guess you wouldn't need to, right? You can say these are things that you've observed, and then the other people get to ask you about it on cross, or... Destiny, they should be objecting to make them at least put in the evidence instead of just letting them get away with their characterization of the evidence. Okay. Okay. Person know that or let me rephrase that, has he told you previously about how he can get his fans to do what he needs them to do? Yes. Okay. Can you tell the court about what he's told you with regards to that? It was in the situation with his ex-wife. After he had her sign the NDA. He wanted me to go after her. May I give context? I don't want to go into what is the issues in the NDA. Okay. Just answer the question. What he told you specifically about having his fans do things. Yeah, that if you kind of guide them into the right direction, that they'll know who to attack. And he's done it to multiple people. And how have you seen him do it to multiple people? Enviosity was one example. Is that a streamer name or something, I guess? He has a lot of, I guess, beef with a lot of people. I can't even count in his YouTube videos. He names each of his YouTube videos after the person he's going after in the video. Okay. Oh, that's a gacha content creator. Okay. And what is your concern with regards to what happens if this protective order is not granted after this hearing today? He is going to continue, as he's shown before, relentlessly harassing and threatening me to the point of where I will probably have to take measures where my life may be in danger. A17, he posts in October of 2021. What does he post? Proud to be blocked. Women who falsely accuse men are scum and should be in prison. Proud to be blocked by women who falsely accuse men. Proud to be blocked. Women who falsely accuse men are scum and should be put in prison. Maybe there should be a period there. Are you falsely accusing him of these actions? Absolutely not. Okay. Did they in fact take place? Yes. A19, what did Tectone say? And this was actually before the protective order was filed on June 18th, 2025. I'm excited to be called misogynistic for thinking women are smarter than people believe and that the bad actors who lie and scream I was manipulated are going to make it harder for real victims to be taken seriously. Did you think this post related to you? Yes, because he's already said publicly that I ruined it for other victims. Okay, when lawyers tell you don't tweet about your case or whatever, the thought is that like you think you're going to be smarter than whatever, but you're going to fuck yourself. Tectone is taken to the next level. He's just fucking torpedoing his own shit. He's not even going for like, he's just fucking himself. Holy shit. Okay. Jesus, Milo tweets. We'll look at that next. God damn. He said, you specifically, yes, he made a tweet with my name specifically speaking about me. All right, let's go to 20, please. On October 27th, 2025, what did he post? To all the OnlyFans whores trying to give me life advice, bro, I can see your asshole for less than buying a Fortnite battle pass. Shut the fuck up. Is this how he would refer to women in front of you? Yes. Okay, let's go to 21. All right. And then on, it looks like again in October of 2025, what does Tectone say? Who will be the next OnlyFans girl to call me out? Bought their likes, then lock the comments. Holy fuck. Absolutely rent-free in their minds. Get back to making your family shameful of your existence. And did you believe that was referencing you? It was possibly, just kind of like I said, getting his audience to have a certain view for when he attacks me. And then it was set for court, I think, in December, correct? Yes. One of the extensions? Yes. All right. May I approach? Judge, you may. Do you have any objections to 31 and 32? Mr. Purrier, no. Applicants 31 and 32 are admitted. There was an agreed order for an extension of a protective order on January 23rd. Is that your understanding or recollection? Yes. Her lawyer says, Judge, I would ask the court to take judicial notice of the agreed order of extension of protective order that was signed on January 23rd. So this court sees what it's going on. All right. I would ask the court to take judicial notice. Shortly after that extension, did Tectone post again on social media? Yes. All right. And in fact, on December 12th of 2025 in Exhibit 31, what did he post? Destiny, 100% Tectone is going to watch you and try to run with whatever defense you're giving him now by just reviewing. I'm not giving him any defense. This is her side, her testimony. I mean, this is all pretty bad so far. I'm going to see how what his legal strategy is here for this. Jesus. You got no idea how hard it is to find a woman that isn't a psychotic entitled cunt. Men got it hard. All right, and did you take that as directed towards you? Yes. Why? It is the same verbiage that he's used multiple times when describing me and describing you publicly or in private. I believe he just calls me crazy and psycho, is what I believe he said on his streams about me. All right, we'll pull up 32. And then on December 17th of 2022, what does he post? No, we do, but modern feminism have convinced women that a man wants to protect you is manipulating you. Women have grown ungrateful and entitled and expect to be taken care of and protected, but aren't willing to do their part of the relationship, and they say you're abusive. Gee, what does that mean? What is their part? Jesus. And that was all while there was that emergency protective order in place. Is that right? Yes. How did this compare to what he had posted before the protective order? Like, what's the difference between very tame? Okay. And what were the ones like before? He explicitly named me and gave it lots of threats. All right. No objection. All right. That was applicants, 33, 34, 36. She's entering more. What else did Tectone post while the ex parte was in effect? Any woman that lies about sexual assault, sexual assault, or rape should be punished to the fullest extent of the law. They should be excommunicated from every group they're a part of, and people knowingly weaponizing their lie should be held accountable as well. So in the earlier part of this interrogation, or testimony, you wouldn't say interrogation, right? In the earlier part of the testimony given, right, the attorney was careful to lay out like, well, who is this guy? Well, he's part of a huge streamer group. He's part of a big management group. He's in control of a lot of clout and influence. He has all of these things to a much greater level than I do, right? So now that foundation has been laid, now these threats carry a lot more gravity with them as well, right? Like, oh, like he has the capability of doing these things because of stuff that we've already factually laid out before getting to this part of the questioning. Which all goes to the strength of why I need a protective order, because he has the ability to, as I laid out earlier, and then the means and the desire to, like he literally is doing this, like he's already kind of enacted this type of retaliatory behavior. Yeah. And on 34, what did Tectone post? Lying women have far too much power today. Did you believe that was in reference to you? Yes. And then judge, I'll ask the court to take judicial notice of the extension of protective order, blah, blah, blah. All right, so I'm going to show you 836. This was on January 6th. Do you recall this? Yes, yes. What does this tweet say? Sorry, what does he say? I'm a patient man. No matter how long this takes, I don't care. Justice will come. I will not fall off. I will return to my life soon. And in the meantime, I'll keep living, working on myself and growing. I'm not worried. I'm looking forward to the future patiently. And how did you take that post? He's treating this as some type of criminal court case rather than me needing protection because of his harassment and threats and the abuse. This is what I don't get from Tectone's part. Bro, why not just stop fucking talking to her or talking about her? Like, it sounds like he designed his own trap so hardcore. Like, why did you keep prodding this to get this to the level of her seeking a protective order against you, especially when in Texas, those protective orders related to domestic violence or whatever the fuck can come with you losing your right to own a firearm? Why the fuck would you keep doing this? It's so stupid. Like, it's not like she's just suing him out of nowhere or she's just like attacking him or whatever, but it's like he continues to prod. Like, what the fuck, bro? Jesus. And what are you asking the court to grant? Are you asking the court to grant the protective order? Yes, please. Okay. And are you asking the court to prohibit him from going within 200 yards of your residence or place of employment? Yes. And are you asking that he be prohibited from engaging in any conduct, either online or otherwise, that would harass, annoy, alarm, abuse, torment, or embarrass you? Yes. Judge, I've got some video that I just need to queue up so I could take a break. Why don't we do that? Let's take a 10-minute recess. Thank you, Judge. 10-minute recess. Let me use the restroom real quick. 1 sec. Jesus. Ooh, okay. All right. What I'm going to show, Judge, is the clip from what is A38, applicants 38, which we'll move to admit in its entirety. We're not going to show it in its entirety, but have a clip set up. Any objections? Video played. Wait. Ooh, no objection. All right, A38 is admitted. Permission to publish. You may. Thank you. The video is played. And then Tectone's lawyer says, actually, Judge, I should clarify, I haven't viewed this. I don't have any objections to authenticity. I should reserve objections to content. But for time's sake, I'll lodge those objections if they're necessary. All of these are part of the initial application, right? Why has he not reviewed? Why have you not reviewed all of these? All of this should be available to the opposing counsel, right? No? Ooh. Okay. I understand. Okay, no problem. And this was done that was published on May 12th of 2025. Do you recall seeing that stream? I didn't see the stream. I saw clips afterwards that were posted online. Jesus, yeah. Okay. Okay, and these were the clips that were posted specifically. Did you think these specifically related to you? Yes, he was speaking about my case. All right. And what are the concerns about, if any, about his comment of just going nuclear? That was just based off the police report, and so that's why he was publicly anticipating and consistently attacking me. I'm sorry, can you repeat the question? Sure, when he said, what were your concerns about what he would do, if anything, when he talked about going nuclear? Possibly, most likely post the revenge porn, obviously threaten and harass me more. And that's when I got really scared that it might get to the point where it will get dangerous for me to even leave my home. Okay, and we're there. Let me back up a little bit. Have these types of posts continued post the granting of the temporary ex parte protective order? Yes, a lot. Okay. Are they as descriptive as these particular posts? Yes. All right, and this judge is August 16th of 2025. It's applicant's Exhibit 45. Like we've indicated before, we'll provide the entirety. Blah, blah, blah. We're just going to show a segment of the video. There's a video played. Okay, just going to show another portion. Any objection? Again, at least authenticity to the last clip. I guess I don't understand what the relevance of any of that was. Worrying about being killed, schizophrenic. I understand the desire to, well, I'll strike that. Okay. I just don't know how that applies to what we're here for. Okay. How was that? I think that was applicant's 45. How is this relevant? Sure, Judge. One of the issues at stake is that he's got an untreated, okay. So I don't know how much, when I say like, well, why wouldn't you lodge this objection or whatever? Okay, I don't know how much this plays into court strategy or whatever, but it might be that like your client is fucking cooked and you know that he's cooked and you don't even want to ask, you don't even want to do like, oh, objection, relevance or something like this, because all you might be doing is giving the opposing counsel time to establish a whole bunch of stuff on their own that they might not be able to say otherwise, right? So like this whole line of argumentation is something that you hope under direct examination your lawyer makes to the judge, but maybe when you say objection relevance, maybe the opposing counsel is like, oh, you want me to explain why I think it's important? Great. Sure, Judge. One of the issues at stake is he's got an untreated mental health condition. It's schizophrenia. It's pretty serious. He carries firearms. He bragged about it online, and that gives her concerns for her safety, considering the continued pattern that he has. In addition, that he's paranoid about her and admits to seeing hallucinations that he's admitted to publicly online to over 1 million streamers that he's got following him. It gives real concerns for her personal safety and grounds for the protective order to be granted. All right, objection overruled. Applicant's 45 is a minute. This might be a thing you don't ever want opposing counsel to have the ability to like say stuff like this. So maybe you don't lodge the objections because you just want them to present shit on their own, because you know that the more they talk about it or the more they go over something, the more like fucked you might be. Wait, did I miss a kick thing? You broke RJ Forehead's heart. Shit, wait, hold on. Destiny, it's a balance of whether the objection will hurt you and what you're talking about, or if you want to preserve it for appeal. Well, I don't know for stuff. I don't know the likelihood of appealing successfully on stuff like this. Also, if you think your client's cooked, you might just know that like it's fucked. So there's nothing to preserve here. Like if you lose this, you're probably not winning on appeal. Maybe. I don't know. Wait, what did I miss in Kick Chat? It's not showing up on my events, Denny. He left already. Wait, oh no. Oh wait, was it PJ Forehead? Wait, did he get 47 today, right now? Well, if he did, I love you. Thank you so much. This resets every 5 days. Is he really gone? Well, I love you, PJ Forehead. Wherever you are now. Okay. You fucked that man, true. Rip. I'm sorry. What is this? A new hit piece about you. 52,000 views 6 days ago. I'm good. How can Rape Tone, someone who is supposedly making over 100K a month, get stuck with, and I'm being generous here, such a mediocre lawyer? Well, it might be that he's like legitimately fucked, right? This just might not be a thing he can argue well. I don't know if his lawyers are mediocre or not. Also, you have to do some work for your own court case. Like, a lawyer is not going to go and watch every fucking video that you've made or watch every fucking thing that the other person's saying. Like, you have to submit, like, you have to be in active communication with your representation to get them the stuff that might be relevant to your court case, right? So I imagine it's you having a conversation with them probably requesting like, hey, if you think there's anything beneficial to you that would help in this or this, like, please give it to us. Like, unless you want to pay a law firm, $20 million to go online and pay all of their associates and juniors to go and watch through 50 billion fucking hours of streams. I don't even know if most of them have the time or desire to do this, so. Okay. All right, objection overruled. All right, and this one is from January 14th, 2025, video played. Judge, we're trying to move to the next part. It's not time-stamped. All right, we listen to that. He's talking about the case. Tell the court what it does to you when you post this kind of content. It's degrading, it's scary, it's embarrassing. Like, I don't think anybody wants somebody consistently just calling them these things publicly for everyone, their family, their friends, my colleagues, everyone to hear on a consistent basis. And did he ever, I'm sorry, and do you believe that he's doing this intentionally, knowing it's going to harm you? I believe he's doing this to harm me. And because I went to the police, he just wants me to let it go, the case. And has he engaged in this repeated pattern of making online comments on his streams about you since he went to the police in January of 2025? Even before the police, okay? And in fact, and we won't get into all of it, but you actually created a timeline that is everything that he actually posted on you over the course of a year, and it's how voluminous is it? Over 200 pages, and that's just the timeline, right? Wait, has this been submitted already as an exhibit or as part of the complaint maybe? Or the affidavit, I guess? And do you believe that you will be safe if the court does not grant you this protective order? Absolutely not. Do you believe that he will engage in a continued pattern of harassment of you if this protective order is not granted? Yes. All right. I pass the witness. All right, Mr. Puryear. Thank you, Your Honor. Cross-examination. All right. Okay, this is our epic suits moment. How do we fucking save our client after this? Woo! All right. Good luck. You have a First Amendment right to shit on people. You have a First Amendment right to shit on people that are filing court cases against you and police reports against you. I feel like the major scary part here for the client, I'm vibing this out so hard right now. I don't know anything about family law or DV or anything, but my vibe is what you really need to establish is that he might talk a lot of shit, he might say a lot of crazy stuff, but he's not actually a threat, okay? He has a First Amendment right to express discontent, to express anger, upsetness, resentment, to call her a bitch, whatever. He can do that. That's his right. He has a right to do that. But he's not actually a threat to her, and here's why. So he's going to have to do something. Bro, saying that you're schizophrenic and you have guns and you've hallucinated seeing her, and then you're like threatening to release revenge porn of her, and then that's like, there are criminal things underlining a lot of this behavior. All right, good luck. Don't worry about the public statements. You just got to get him off is he really a threat? I think. That would be my guess, but let's see what he does. All right. Cross-examination means opposing counsel, the lawyer for the other party, is now asking you questions. Pinkchyu, I'm going to ask you some questions. If I ask you something that's confusing or in any way doesn't make sense, just let me know, okay? Okay. And do you go by Pink or Pinkchyu? Pinkchyu. I'm just kidding. What's that? I go by blah, blah, blah. Okay, that's my middle name. Is that how you want me to address you? Yes, please. Okay, all right, Pink. I want you to take a second. All of those exhibits that your attorney just admitted, they're bullshit, right? Can you point out for me where in those exhibits it mentions blank, blank, Pinkchyu, Pink, or whatever? In my timeline, there is multiple situations and pages. Okay. I want you to take a second and review all of those exhibits. Can you tell me where in those exhibits it mentions your name exactly? Okay, so careful, okay? Just remember, okay, I'm not a real lawyer. I'm not even a lawyer. I'm not even a pretend lawyer, okay? If you want to go to a judge and you want to argue like probative value or evidence, like why should something be allowed or not allowed as an exhibit into evidence, that's a really good fight to have on a very technical level in front of a judge. Because if you win on some, I don't know if this has to be done, this is like a pre-trial motion or some evidentiary hearing or something. When you do this and the judge throws it out, that's evidence that's not even allowed to be considered now, right? The jury can't hear it. The judge can't hear it. Well, the judge will hear it if they do a bench trial for the judge listening, but he won't consider it, right? It's gone, okay? So if you can make those arguments for why this piece of evidence shouldn't even be considered, that's an amazing argument to make. It helps your case significantly, or it should if you're trying to get it tossed. If you allow evidence to be submitted and you want to attack the credibility of the evidence, I think you have to be really careful not to make Reddit tier arguments, because like obviously the judge or the jury is going to consider that. So like if you're trying to make some argument to a judge in terms of like this evidence shouldn't be submitted because there's not even a name on it, if you win on that, then congratulations, you fucking won, and it's not even going to be shown to the jury, or the judge can't consider it for a ruling. But if it's submitted and it's very fucking obvious to everybody, like it's very fucking obvious, this is obviously talking about her, and you're trying to like do, it doesn't actually say your name, right? It just says OF goth slut big titty mama, right? But that's not actually your name, is it, right? Everybody's going to know. Well, obviously it's fucking referring to her, right? And I think that I feel like her own lawyer laid out a pretty compelling line of argumentation for why all of this referred to her. So I think, but I'm judging his argument just based on the first two questions. Maybe he's going to lay out something more compelling than this, right? But making these like cutesy arguments on like hyper technical levels when this is all going to be stuff considered, by a jury or by the judge if he's doing a bench trial is not very compelling, in my opinion. But what do I know? Are you speaking of these printed ones or the ones that were on the screen? Either. I do not believe in the short clip section my name was mentioned in the clip section. Okay, I agree with you. Can you point out for the court any time in any of these admitted exhibits where it mentions blank, blank, Pink, Pinkchyu, or blank? Not that it was shown. Okay, also, and again, I don't know how much prep she was given for this, okay? These are good answers. So I think that like, sometimes you might fuck up here and it's like, can you show where your name was mentioned? And you might start yapping on some crazy shit. Okay, my name wasn't mentioned, but like, I think in the past, I think he said things or whatever, and you might start yapping on some shit that's now fair game for them to cross-examine, and you might fuck up and you might fuck a whole bunch of shit up. Having the confidence to stand by your answer, saying, no, my name wasn't referenced here. And just saying that and being done with it is a good answer, okay? You're not yapping and giving them some dumb shit to start unspooling your testimony on. Okay, I agree with you. You would agree with me that, strike that. Has John ever text messaged you since the application? Well, have you ever expressed to John until the protective order was filed that you didn't want him to contact you? Yes. Okay, how did you do that? How did you communicate that? From my mom. Okay, so you had your mom call him and say she doesn't want you to call anymore? He called my mom. Okay, and was that conversation recorded in any way? No, but I believe was it memorialized in text message in any way? Yes, in writing. I believe they were in text messages. I don't know if that's when she said it was over the phone or through text. Okay, and I would assume if it's in text, you have a copy of that? No. Oh no, okay. Until the strike that, okay. Also, again, I'm not a real lawyer, but like, you're never really asking questions. By the time you go on to trial, or I would imagine for a hearing, you're not asking questions that you don't know the answer to. I imagine you would have requested this via something, no? Or no, because they're not technically to the discovery part of their case yet. Would you subpoena for it? Asking questions like this and not knowing where the answer would be, this seems really scary to me. But maybe for these types of hearings, maybe you just don't know ahead of time. So maybe you're just gambling on it, I guess. I don't know. Okay, until the strike that. Since the protective order has been filed, has John text messaged you? No. Has he emailed you? No. Has he called you? No. Has he communicated with you by social media? Are you speaking as of since the temporary orders? Facebook Messenger, over direct message on Instagram, any communication at all? My confusion is, are you speaking from since the protective order? Correct. Since you filed the application for protective order and the temporary protective order was granted. No. Okay. I do not believe so. Okay. Have you seen him outside your house in your neighborhood? No. Okay. Has he approached you? No. Okay. I want to ask you again, how did your relationship with Tectone start? Who contacted you? I reached out to him because his friend asked me to reach out to him. Okay. But your friend didn't type out the media message, the social media message to Tectone, correct? No. You messaged Tectone, is that? Yes, correct, okay. And when you messaged John, you all begin a romantic relationship? No. In December? What's that? Oh, no, not when I messaged him. No. At some point following that message to John, you entered into a romantic relationship sometime between December of 2022 and let's say July of 2024. I don't know why he's going. I feel like as a lawyer, you want to. I don't know why I'm giving advice on that. I don't know. You ask questions to like build up to big conclusions, right? Like, I want to say that she lied about the sexual assault. I want to say that she's not under a threat of a particular thing, of being harmed, and that she is, I don't know, a bitch or whatever. So you like ask questions like building up to this, building up to this, building up to this, and then you get your killer question, right? Like, have you ever seen this or whatever, right? It's no. And then you go back to like establishing questions, foundation, and then you get your big question, and then you do this. I don't know why he went from like, was Tectone, did any of these things mention you? And now he's hopping over to the romantic relationship part. Maybe that's all he really has to say about these. But I feel like you would want to build further to that. But I don't know, what the fuck do I know? I don't know, maybe who knows. At some point following that message to Tectone, you entered into a romantic relationship sometime between December 2022 and let's say July of 2024. Yes, at some point, yes, you guys were a couple. Is that fair? Yes. Okay, well, I just want to clarify because you provided some testimony on direct that the only reason you slept together was because he had a mental health diagnosis or he didn't want to sleep alone. I mean, you guys were a couple. Is that fair? Yes. Okay, I just want to clear that up because the implication from that was that you were roommates, but you were only sleeping together because you were scared of the dark or something like that. I mean, you guys were a couple. You slept together in the same bed like couples do. I prefer it a lot of times to sleep upstairs. Okay, have you ever expressed something different in a text message to John? I believe it was over Snapchat. I would tell him I'm working or I'm going to sleep upstairs. Okay, and I'll just say it for the purpose of our cross-examination. I'm familiar with the text message history between you guys. I mean, you guys, again, you all were a couple and you slept in the same bed. Yes, periodically we did. It was both. Okay, did you engage in consensual intimate encounters? There were times before I moved in, yes. Okay, and I think it's fair to say, well, strike that. Your date of birth is, yes, is that correct? You made a statement, well, strike that. Oh man, this guy's sweating. Are we okay here? From a personal perspective, do you want partners to be invested in your career goals? Supportive. Okay, great, thank you for clarifying. Do you want them to be supportive of your career goals? Yes. And John was supportive of your career goals. Is that fair? You testified about him wanting to kind of promote your presence online to try and help you achieve more visibility, more popularity. Those were all things that you wanted. Is that fair? Man, again, that drawing that I made, like her lawyer was very good at building up you're laying so much foundation to get to your big conclusions at the end, right? Like you wouldn't just say like, John raped you, right? You would lay all of when did you guys meet? What was your sexual interactions like? Did you ever file a plea? All this. And then you say, oh, do you feel like he, sexually assaulting you or whatever, right? You build up to all these things. This guy seems like he's just hopping around on some random shit, but damn, I don't know. Also, you should have like your lines. I would imagine this to be the case. I guess I don't know, but I would imagine as a lawyer, you have all of your lines of interrogation plotted out beforehand, right? You expect to go down all of this, and then all of this, and then all of this to build to the conclusions that you basically want to be presented to the judge about a particular thing. But, geez, okay. Okay. I think so, yeah. Is her lawyer really good, or is Tectone's lawyer bad, or is Tectone just so fucked that the lawyer can't really do much here? I mean, it doesn't seem good so far. But what do I know? Again, careful. I don't know. Yeah. Okay, and John was supportive of that. Yes, okay. If you had a partner that wasn't supportive of your career goals, that wouldn't be a very good sign of a mutually supportive relationship. Is that fair? Yes. Okay, but the inclination on direct was that him wanting you to help you out, that was a bad thing for whatever reason. It was the dynamic, the power dynamic, okay, that he had more fans online and you didn't. He had more control over not just online, but also with companies and stakes and companies and partners. Okay, and I mean, it could, correct me if I'm wrong, it sounds like he was leveraging that influence he had in your industry to help your career out. Is that fair? Whew, I feel like you're going down like this is like such a scary line of questioning for you. Whoo! Like, because to some extent here, you're treading on dangerous grounds because I feel like that's part of what you want to establish on direct examination. Like, this guy had a ton of control over her. He could leverage a lot of his power to help further her in her career. Like, that's what the direct examination, like, I feel, again, I'm going to stop hedging. I'm sorry. I haven't tried cases, obviously, maybe. But, like, I feel like you would want to do the opposite. It's like, didn't you have this social media? He didn't help you at all with that, right? Didn't you say you started an OnlyFans? Did he ever promote that? No. Like, here are all the reasons why you make so much money now. You do all these things that are completely independent and outside of his reach, right? I feel like that's the type of stuff you would want to establish. Because, like, Judge, she doesn't need a fucking protective order. Like, this is influencing parts of her life that aren't even materially relevant to her. She doesn't make any money from shit that he's involved in. But he's going right into the, like, Tectone is leveraging his position in the industry to help you make more money, right? Yeah, the same guy that's now threatening to take it all away. That's correct, you know? That's what it feels like is a bad line of argumentation, but I don't know, who knows? Somebody said, they're also on cross right now, so they need to stay within everything that was brought up during direct questioning. Maybe they have a strategy for when they call her back up later for direct. Yeah, I guess. This feels like a spooky line of argumentation. I don't know. We'll see. Who knows? Maybe I'm retarded. I could be retarded. Okay. People keep saying it seems like Tectone was too lazy to properly inform his lawyers of the situation. I don't have any evidence of that. That might be true. I don't know if lawyers would ever say that. Well, you probably wouldn't because they want to throw your client under the bus, but maybe. That would be really bad too. Don't lie to your lawyers. You're fucking yourself up. Even if you did it bad, don't lie to your lawyers because they might be able to help you with stronger arguments that can get you off or get you less penalty. Like, yeah. Okay. Is that fair? Yes. Okay. Was John physically abusive to you? In which way? Would he hit you? He did shove my head into his crotch one time. Okay. Would he strike you with his hand? No. Okay. Would he kick you? No. Okay. When did the alleged sexual abuse begin? The coercion began when I moved in, and it got more aggressive as time went on. Okay. When I moved into the when I moved into the Chestnut Ridge Road address. So is this December of 2022? No. That's when you guys met? Yes. Okay. When do you think you started dating? I believe a couple of weeks after we met. Okay, so maybe end of December, beginning of January, something like that. Sometime in December, I can't remember. Okay, and so when did the alleged coercion, when did that begin? When I moved into Chestnut Ridge Road address. Okay, and I apologize. I don't know when that was. Do you remember like a month and a year? I believe it was possibly February of the next year of 2024. You should have the timelines on this. Is super important. You would never wing a cross-examination, right? I imagine you would prepare in advance, like the questions you think they're going to get and what your approach would be, right? You would never wing this, would you? February 2024. Okay, that's when the coercion began. Yes, when I wasn't paying rent and we were into the new home. Okay, and in your application, you state that around February or March of 2023, you told Tectone that you didn't want to live by this agreement anymore. What agreement was that? He's asking when the alleged coercion began. She's saying February of 2024, but she moved in March of 2023. Are they mixing the years up now? Destiny, could that not just be his style of asking questions like, I forgot, can you state it? I mean, you could, but you're relying now on like unforced errors from the other side. you could just say, I don't remember. Can we consult like an exhibit that's already in the record? You say, I don't remember. Like, let's consult. We've got exhibits for this that have already been entered into evidence, you know? Yes, when I wasn't paying rent and we were into the new home. Or I could be mixing a year up as well, but I don't know. Okay, and in your application, you state that around February or March of 2023, you told John that you didn't want to live by the agreement anymore. What agreement was that? I wasn't paying rent. In my perspective, I thought it was because I was going to help him with thumbnails and graphics. And he had stated during intimacy that it was for not, that I wasn't paying rent because I was giving him blowjobs. And he stated in quotes, do your job, you don't pay rent. But it sounds like you guys were already in a romantic relationship by that point. That's why I was disgusted and confused. Okay, what was disgusting and confusing? That I thought I was his girlfriend, but he's treating me like a prostitute. And did you break up with him at that point? I told him that I wanted to pay rent. I hoped it would stop after that. I had already sold all my items in my home, canceled my lease like he asked, and I felt stuck already, and it's not that easy to just move out. Okay, you were working online. You were, I think, doing some modeling, doing some acting, and I'm not deeply familiar with kind of this world, but is that generally what you were doing? I was doing, streaming and modeling. Okay, and your income streams from that? It was not as high as it got later when I began in OnlyFans. Okay, but there was an income stream? Yes, but it was not that high. Okay, now he's going into like trying to establish different income streams. I don't know why he wouldn't couple that with the question from earlier, but okay, I don't know. Correct, but my question was, there was an income stream? Yes. And you were making money from that? Yes. Okay, and certainly the situation was coercive enough. If it was bad enough, you could have moved out. Is that fair? No. Why? Man, you're really, you're really giving her the chance to speculate on here. Okay. No, because like I said, he does have a lot of power and control and the power dynamic. I just felt like I was just going to start paying rent and, that was going to stop and I was going to hopefully move on from that. Okay, but John wasn't keeping you in the home. He wasn't physically keeping you in the home. How so? Explain what physically keeping. I'll strike that. And you reported this alleged sexual abuse to the Austin Police Department? Yes. Okay, when was that? I believe it was in early 2025. Okay, and Detective James Thrift, does that name sound familiar? Somebody said, I think Tectone literally gave these guys nothing to work with. It might be that, like, if you have nothing to work with, though, you always have something to work with, okay? You've got the process, all right? You always have something to work with. I feel like if you know your client's fucked and you're trying to save legal fees and harassment and time and expense and everything on both sides, then you could, like, try to make an order. You try to make an offer. Like, okay, listen, could you mutually agree to a restraining order? I don't know if you can have, like, I don't know if both parties can consent to an injunction. I don't know what things, but maybe something where it's like maybe it wouldn't be a restraining order or it wouldn't be an injunction. It would just be like an agreement, a court order or something. I'm sure you could mutually assent or consent to a court order, but it's like, listen, my partner doesn't want, or my client obviously doesn't want to lose his rights to own a gun forever, but he will agree never to mention you again, never to do this. Like, let's see if we can settle and come to some kind of agreement, basically. Like, you would at least work that angle rather than, we're going to go to court and we're just going to fight. We're going to fight on everything, bro. We're going to let it fucking ride. We're going to let it ride. And if you lose, you're fucked. That just seems, I don't know. I'm not sure. You can consent to a protective order, an MOJ. What is that? Motion of judgment? Memorandum of judgment? Milkers of jugs? I don't know. Okay. And you reported this alleged sexual abuse to the Austin Police Department? Yes. Okay. When was that? I believe it was in early of 2025. Okay. And Detective James Thrift, does that name sound familiar? Yes. He was the detective assigned. Is that correct? Yes. Okay. Would it surprise you if that investigation had been suspended? I suspended it. She did say this. She testified to this. You suspended it? Yes. Oh, does he not know that? Because now he has to abort this whole line of questioning. He must have known that. No? Okay, so it was your request to suspend the investigation? Due to all of the threats and harassment, I couldn't do what the officer was requesting for my safety. Okay, but you proceeded with filing a protective order? Yes, and hopefully after the protective order, if I feel safe and comfortable enough, I will probably most likely reopen the case. Okay, I want to ask you about another police report that you filed. This one was back in February 12th, 2024, and you called the Leander Police Department. Is that correct? Yes. And at the time of the report, you were residing with Tectone at On, is it Venezia View? Does that sound familiar? Yes. Okay, at that time, you were residing with Tectone? Yes. And you made that report because Tectone's ex-wife, Jessica, had messaged Tectone something like, is she better than me? That is not why I made the police report. That wasn't my question. Okay. Did John's ex-wife message him something like that? Is she better than me? Well, okay, this is not the same question that you... It's not the same question the answer here, but okay, base. Oh my God. All right. Is she better than me? That is what he told me. I did not see it. Okay. But that's what your understanding was, what Jessica told John. Is that fair? This is why, like, you lay foundation for things, right? I don't know if the other lawyer should have objected here or not, but like, you made that report because John's ex-wife Jessica had messaged John something like you would ask questions leading up to this, like, did you see his text messages? Are you aware that he texted that he received a text message from Jessica? What did that text message say? Are you aware the and then you would ask like you would make. I don't know if you're allowed to have a leading question like that. If it's under cross, you might like you filed a police report because of ABC or whatever. But I feel like you would have to. I feel like it's just better to build to things like this. But I don't know. Maybe I'm retarded. That is what he told me. I did not see it. Okay. But that's what your understanding was, what Jessica told Tectone. Is that fair, John? Yes. Okay. And you made a report on the basis of a suspicion that Jessica had videos of you and John engaged in intimate activities. Yes. And you believed that she had those recordings from what I was told. Yes. Okay. From what you were told by who? Mr. Robinson. Okay. By John. John. Yes. Okay. And you believed what he told you because your next action was to call the police. That was not the timeline of events, though. Correct. It was about 14 months after he told you. Is that fair? It was after multiple people have told me that they were sent that. After multiple people were what? Stated that they were sent footage. Okay. And these multiple people, did they ever provide you any of that footage? No. Okay. So you don't have any independent evidence or verification that anybody that had any footage ever. Is that fair? No, there was some footage. It just wasn't sexual footage. Okay. But to be clear, you never saw any video footage? No, I was believing John and his friends. Okay. When did Jessica message that to John, to your understanding? The first time? Uh-huh. Don't ever, you should be saying yes or no, okay? As a lawyer especially, yes or no, never uh-huh. Because you could say stuff like that, right? It's confusing. Usually court reporters or whatever will tell you, could you please answer clearly yes or no? Or usually a lawyer will remind you. But I believe that was in December of 2022. Destiny, during cross, are you allowed to ask the lawyer to clarify the question? Then if they oversimplify the question, you can answer to the oversimplification and not technically be lying. I guess, sure. You could say you don't understand, or could you clarify? And then yeah. I mean, it's up to him. It's up to him. You don't have to help him ask questions. You can just say, I don't understand, or can you clarify, or repeat the question, please? Yeah. You don't have to. That's his job. If he's asking questions that are ambiguous or don't clearly establish what he's trying to establish, then yeah, that's on you. And then if you try to refer back to that testimony later on, I think theoretically you could, I think the other lawyer could object to like objection mischaracterizes evidence, or objection states evidence not on the record, or mischaracterizes. I don't know what all the fucking objections are. I don't know, whatever. But like that wouldn't necessarily work. It could be bad. Yeah. You should be asking clear and concise questions, right? I believe it was in December 2022. Okay. And is that when you learned about it? I didn't understand the full context. I just knew it was some footage, something going on, but I didn't understand the full context. Okay. Judge, may I approach? You may. Have you ever had a different position on when you learned about that footage? I just was told, or that message, I just was told that it was me giving him a blowjob, but I didn't know if it was inside the garage or if it was outside the garage, like the full context of it, because I'd never seen it myself. Okay, let me back up. When did you learn about the message that Jessica sent John? Something to the effect of, is she better than me? When did you learn about that? December of 2022. He said that she called and said that. Okay, I believe. And what did you take from that? I was disturbed. Okay, was Jessica there? Jessica where? Was Jessica in the home when you guys engaged in intimate activity with each other? I feel like this line of questioning is not very clear at all. What do you call it? Is it a litigator when you're actually like in front of the judge and asking questions? I feel like this guy is not well practiced in like direct or cross. I don't know what you call it, litigating or whatever. I feel like this is all like kind of a mess, but no. So the implication from that message to John was that she was viewing what you guys were doing in the house someplace else. Is that fair? Yes. Okay. Did that concern you? Yes. Okay. And you learned about that in December of 2022? Yes. You didn't report it to the police for some 14 months until February of 2024? Yes. Okay. And on that date, you spoke with Officer Alyssa Hoffman. Do you remember that name? Yes. And she's an officer with the Lander Police Department. Is that correct? Yes. And you reported to Officer Hoffman that John's ex-wife, quote, had recorded you engaged in sexual contact with John. Yes. And you wanted to file that police report against her because you believed she had been monitoring cameras in the house and recorded you engaging in the sexual conduct. It's because she was sending it to multiple people. Okay. And at that moment, when you were speaking with Officer Hoffman, you believed that Jessica still had videos of you and John engaged in intimate activity. Yes. And I'm sure with Officer Hoffman standing there by your side with a badge and a gun and handcuffs ready to arrest John, if he had broken the law, it was over. Oh, sorry. Hold on. My apologies. You certainly would have told Officer Hoffman, Officer, it's extremely important that we get these videos, not only because Jessica has done something wrong, but these videos contain powerful evidence of coerced sexual activity that I've been forced to perform. Sorry, I didn't raise my voice quick enough. Evidence of coerced sexual activity that I've been forced to perform? No. You probably would have told her, I've been coerced into performing oral sex, and these videos will contain evidence of that. Evidence of that? May I explain? Sorry, or you can if your attorney asks you, but, my question is, that's not what you explained to Officer Hoffman, is it? Are you allowed to ask questions like this? I forget, leading is allowed by one side, but not the other. Like, I don't think that under direct exam, you can't lead your own person, but the other side is allowed to ask leading questions or something. Or draw, like, I don't know, it's like, I don't think you can object to speculation if you're speculating on your own behavior, right? These are compound questions, should have objected. Maybe it's that, yeah. Like when you're asking a thing with another thing baked into it, it feels like a lot, but I don't know. Good luck. We need to learn all the objections, okay? My question is, that's not what you explained to Officer Hoffman, is it? Those videos did not contain coercion because it was before it began. Okay, again, this is in February of 2024. The footage was from December of 2022. Okay, and you had, but fair to say, the coercion, according to your testimony, had started by February of 2024? Yes. And you had every opportunity to tell Officer Hoffman on February 12th that John was sexually abusing you, and she could have acted on that. Is that fair? We only spoke through email and specifically about the case. So Officer Hoffman never responded to Venetia View? No, she did not. I never met her in person. Ooh, how, does a lawyer does not know this, or is she wrong? Okay, she's sitting outside. She's going to testify. Are you sure that's your testimony? From what I remember, we had gone through email and phone call. Okay, and if she reduced her interaction with you there at Venetia View to an offense report that was filed, would that be incorrect if she represents in that offense report that she spoke with you? I just don't remember. I don't know. Okay. I just remember us going through back and forth through email and phone calls, so I couldn't recall if I'd met her in person. She shouldn't speculate here. If she doesn't think she did, she should just say no, or I don't recall. She doesn't need to offer up more stuff here. But how many interactions with law enforcement have you had in your life? I would hope for this lawyer's sake, though, that he is correct, because if she hadn't actually met this officer in person, this whole line of question I think is really bad too. You can lead and cross because it's meant to only be yes or no questions. Okay, gotcha. How many interactions with law enforcement have you had in your life? How many times as an officer? Strike that. How many interactions with law enforcement have you had in your life? Possibly 3. Okay, so fair to say that an interaction with Officer Hoffman on your doorstep in your house, on the sidewalk outside, that would have been significant for you. I just can't remember. It was so long. It was a couple years ago. Okay, so it sounds like this lawyer knows that she did have an interaction in person with the officer. I would hope so. That seems like it. I just can't remember so long ago. Okay, and fair to say that you didn't disclose anything to Officer Hoffman about any sexual abuse that you were allegedly suffering at John's hands. At the time, I didn't know what to call it. Okay, and did a detective with the Leander Police Department ever follow up with you about these allegations? It was very difficult going back and forth over the phone. So I don't remember. I'd have to look at my emails. To your knowledge, was Jessica ever this is a stronger line of questioning. He should have opened with this. Jesus Christ. Assuming the facts that he's asserting are true. To your knowledge, was Jessica ever arrested? No. Did the Williamson County Prosecutor's Office prosecute a case against her? No. So that case went nowhere? Yes. Okay, and because that case went nowhere, you filed a lawsuit in the Williamson County Courthouse against Jessica? Yes. A civil lawsuit? Yes. And Judge, may I approach? Meaning he's giving her something to look at. While she's looking through those records, just from big picture, this lawsuit again dealt with Jessica, Tectone's ex-wife, allegedly videotaping sexual interactions, sexual encounters between you and John, and that's again, big picture, kind of what it involved in her alleged distribution of those videos. It was also defamation. Okay, very good. Judge at this time will offer Respondent's Exhibit 1. No objections from opposing counsel. All right, admitted. I'm going to publish portions of this judge to the court electronically. That's all right, sure. By Mr. Courier. All right, Pinkchyu. So I want to ask you a few questions about that lawsuit. And in that lawsuit, you allege several different causes of actions, including unlawful disclosure or promotion of intimate visual material, common law defamation, statutory libel, business disparagement, tortious interference with business relations, intrusion on seclusion, and stalking. Is that correct? Yes. And you filed this lawsuit on June 25th, 2024 in Williamson County. Yes. And that, what we just published as Respondent's Exhibit 1, that's a certified copy of that lawsuit. Okay. Is that fair? Yes, I didn't see it. Yes. And you described your relationship with Tectone as a private romantic relationship on page 6 of that lawsuit. Where I can make it a little bit easier for you. Pink. Okay, got it. You got it. So this lawsuit, and this is the front page of that lawsuit. Is that fair? When did she say the romantic relationship began? Did she say not until December of 2024? Because if so, that's a good point too. Because this lawsuit was filed on June 25th, 2024. I'm trying to remember if that's when she said the romantic relationship began. She said it was a couple weeks after the man in 2022. Okay, maybe she just meant the coercion or abuse started at the end of 2024 then. I don't know, the timeline's 100% on this, but okay, never mind then. This is the front page of that lawsuit. Is that fair? Yes. And on page 6, you refer to the relationship again. Tectone is John. Is that fair? Yes. And Pinkchyu, that's you. Yes. Okay. And so in your lawsuit, it's kind of the background of the relationship between the parties. You describe the relationship that you had with John as a private romantic relationship. Yes. And again, this was filed in June of 2024. Yes. I want to also direct your attention to a second page in that. You, at various points in this lawsuit, discuss or characterize sexual interactions between you and John. Is that fair? The interactions from December of 2022. Correct. And you describe these in various points as private, intimate moments between Pinkchyu and Tectone. Yes. And a romantic relationship between Tectone and Pinkchyu. Yes. And you talk about some of the false statements that people have been making about you and John and the videos that have been allegedly distributed. Yes. And some of the, I think you call them rumors that are online. I believe so, if that's what it says. Please watch the Epstein interview tomorrow, and tomorrow, justice for PJ Forehead. Thank you for your attention to the matter. Maybe, we'll see. Okay, and you said somewhere, quote, toxic lies being distributed and distributing the intimate videos involving you and John. Yes, and how these videos, these intimate images, or these intimate videos allegedly being distributed have negatively impacted your career prospects. Is that fair? Yes. How you weren't getting signed to Mythic Talent as soon as you might have otherwise? Yes. So fair to say from that experience, you have a good understanding of how an allegation or rumors online can affect somebody's career? Yes, because you experienced it. Yes, when you went through this with Jessica. Is that fair? Yes, and you're extremely aware from that experience that an allegation like that can influence the ability to get endorsements? Yes. Okay, and business deals that may happen. It may affect how many followers you might have in any of your social media streams. Is that fair? Not entirely. Okay, what was incorrect about that, or what would you disagree with? I would say similar to kind of how John has dealt with it, is you just go make a pivot to very hateful and opposite types of content to garner new audiences in that sphere. And you can actually grow, is what I've seen people do. And since you, well, strike that, again, you characterize those interactions between you and John as recorded intimate interactions between Pinkchyu and Tectone, correct, for December of 2022. And among those false statements that you identified were that Tectone was grooming you. And then you go on to say that grooming is defined as the practice of preparing or training someone for a particular purpose or activity. In this connotation, Freem, who is that? His ex-wife, Jessica, yes, was implying that Tectone was preparing Pink as a sex slave because she is autistic. However, this is not the basis of the relationship between Tectone and Pinkchyu. Is that correct? That is what's written, yes. Okay, and again, this lawsuit was filed in June of 2024, yes. Okay, and both of the specific interactions that you list in your application for protective order happened before that. Is that fair? In March of 2024. Some of them, But the ones that you list with specificity in your application for a protective order happened in March of 2024, and then in May 28th and May 29th of 2024. Yes. Okay. And this lawsuit was filed less than a month after this last incident of sexual abuse allegedly perpetrated by John on you. Yes. Is that fair? Yes. Okay. But despite that, you are calling the allegation that John was grooming you as a lie. Is that fair? I was not aware I was being sexually abused at the time. Okay. And can you explain that? I did not until I confided to a friend after. I knew what was going on was not good, and I didn't know what to call it. Okay. And that did not happen until after I moved out and confided into someone. But you described for Mrs. Locke on direct that both of these incidents caused you pain. Yes. And was without your consent. Yes. Okay. But it wasn't until you talked to a friend after you and Tectone broke up that you changed your view on these things and decided that it was sexual abuse. Not deciding, that is sexual abuse. Okay, but at the time you filed this lawsuit, you believed that the idea that John was grooming you, or that you were his sex slave, or that that was the basis of your relationship, you believed that to be a lie? I was highly manipulated at the time. That was not my question. Okay. My question was, at the time you filed this lawsuit, you believed the idea that John was grooming you, or that you were his sex slave, or that that was the basis of your relationship. You believe that was a lie? Yes. Okay. At that time, yes. Or at the time, yes. And further, you called them disgusting lies, these rumors that were spreading about you and John. Yes. And further, you believed the idea or the rumor that you were going to have a gag reflex surgery. You believed that was a disgusting lie. Yes. And in June of 2024, you believed the idea that John was grooming you as a sex slave. That was a disgusting lie. At the time, yes. Okay. And again, this is less than a month after this May 28th or May 29th incident that you put down in your application for protective order. Yes. Okay. And in this lawsuit, despite, according to your testimony, having been abused by John, at least in March of 2024, and then in May 28th or May 29th of 2024, in this lawsuit, you didn't describe your relationship with John as one of an abuser and a victim. At the time, I did not. I was not fully aware of what my situation was. My question is, in that lawsuit that you filed in June of 2024, you describe the nature of your relationship with John as one of abuser and victim. In the writing, yes, that's what I wrote. Yes, or the lawyers wrote, put together. Where in that lawsuit do you describe your relationship with John as one of an abuser? Sorry, I think I'm just confused on the question. Okay. In any place in that lawsuit, do you characterize your relationship with John as one of an abuser and a victim? Me or you don't? No. Is that fair? Okay, I don't. Right. Is it fair to say that at no place in that lawsuit do you describe your relationship with John as a sexually abusive one? No. And is it fair to say that in this lawsuit, you didn't describe your relationship with John as a sexually coercive one? Wait, I'm sorry. Repeat that question. At no place in this lawsuit do you describe your relationship with John as a sexually coercive one? No. And despite you filing this lawsuit on June 25th, 2024, less than a month after John allegedly sexually abused you? Yes. And in cause of action number 2, again, you describe this characterization of John grooming you to be a sex slave as false. At the time, in June of 2024, yes. Less than a month after John last allegedly sexually abused you. So what he's trying to establish in this line of question is like all this behavior had already happened earlier. And so when you were filing a lawsuit talking about the behavior at that time, you didn't call any of this, you didn't call it abuse then, right? So why are you calling it abuse now? This is this is a line of, that's what he's trying to establish here, basically, that she's, for some reason, she's changed her testimony, or she's changed her characterization of that relationship. Now she's given a reason why, that she talked to a friend and reviewed it and felt like it was coercive in retrospect. That's her explanation why. The behavior that she explained, though, is pretty bad. So I feel like he needs to figure out how to describe that in a way that's not as bad. Because it feels like this on its own. Because it's probably pretty common that people get out of an abusive relationship and then realize the extent of the abuse afterwards. That's probably a fairly common experience, would be my guess. But maybe he'll build to that. We'll see. Fuck. Are we really only halfway through this? Oh, there's no fucking glossary at the end either? Jesus. It's possible to get a lifter flare? I think you have to email for one. Less than a month after John last allegedly sexually abused you. Yes. So in June of 2024, it was false that John was grooming you. No, just that, just what I had written at the time. I was not aware of what to call what I was going through. But that's what you put in your lawsuit, that it was false that John was grooming you. Is that correct? Yes, that's what you put in the lawsuit. Yes, that's what's written. And in your lawsuit of June of 2024, it was false that John was preparing or training you to be a sex slave. That's what's in your lawsuit. Is that correct? Yes, and then in that lawsuit you filed in June of 2024, that was false, that you were John's sex slave. That's what's in the lawsuit. Is that correct? Yes, that's what's in the lawsuit. On page 13 of that lawsuit again, less than a month after John, according to your testimony, brutally orally assaults you. You call the notion of you being John's, quote, whore, end quote, a, quote, lie without any substantiation. Yes, and again, this is less than a month after your May 20th, 29th incident that you put in your application for protective order. Yes, sometime in the early summer, you and John end your relationship, whatever type of relationship it was, you end it, yes. And that was kind of an extended process. Is that fair? How so? Well, you didn't break up in an afternoon. You move all your stuff out that afternoon. You never see each other again. Okay, yes, it was extended. Yeah, correct. It was protracted. Use whatever word you want. It took a while. Is that fair? It took a while after. It was fairly fast after I got out of the hospital. You mean Austin Oaks? Yes. Okay, but throughout that time, you guys were continuing to communicate? Yes, and you and John continued to be intimate? Yes, consensually intimate. What is the timeline of this? Well, let's say June and July of 2024. I don't know. I'd have to look at the what was going on at the time. Okay, on July 23rd, do you recall discussing a sexual encounter you had with John and describing how hard it was to be, quote, friends with benefits? Do you remember that? Yes. And what does friends with benefits mean to you? That was my first time ever having that, so I didn't. That's just the term he used. Well, if I represent to you that that's in a text message between you and John, and that's a phrase that you used, what would that mean to you? I guess friends who were sexually active. Okay, and you and John were sexually active? Yes. Consensually sexually active? Prior to that, no. Prior to what? Because I do remember there was one consensual action from the friends with benefits situation, but the other times there were not. There were many times they were not consensual. At some point in June or July of 2024, did you engage in a consensual sexual encounter with John Robertson? I believe one time. One time, and that's probably the time that you're maybe referring to in some of the text messages. Is that fair? Yes. Okay. All the other times were non-consensual? No, there were specific times that were, and there were many times that were not. It's very nuanced. Okay, but you guys were broken up at this point? Yes, I broke up with him. Okay, so how would these non-consensual, if you guys are broken up, how would these non-consensual encounters come about? No. Had you moved out at this point? No, I'm speaking about the time that he wanted to be friends with benefits. There was one consensual time, and then that was it. Okay, from what I can remember. And you remember going into Austin Oaks on June 29th, if that's the date that's on file. Okay, and your phone number at the time was this. Yes, is that correct? Yes. You recall texting John the day after, or the day before you went into Austin Oaks at 7:44 p.m. Sorry, last thing is a thank you. Can I suck at your dick tonight? This is what he instructed me to do. But did you send that text message? Yes. So just to be clear, so I understand your testimony, John instructed you to send him a text message asking that you could suck his dick that night. Yes, he told me I needed to ask to suck his dick to show he could trust me because I tried to reach out to another girl and talk about what he'd been doing. Ooh, this is a huge claim. I wonder if they push for evidence of this. That's a pretty killer claim here. What was the date of that? Or what was the date of that? So this is Pink's lawyer asking that question, June 28, 2024. She said, that was the month before hospitalization. Mr. Prager says, that was the night before. No, hospitalization was July. I'm sorry, July 28th, 2024. Okay, thank you. Judge, may I approach? You may. What's the date on this? That was July 23rd. I don't know if she can authenticate it. Judge, may I approach? You may, by Mr. Prager and Pink. That is a fair and accurate representation of those conversations that you had with John, I believe, from July 28th, 2024, leading into July 29th. Yes, I remember. Okay, and this is a fair and accurate copy. Is that correct? Yes, I believe so, yes. And I'm going to mark and offer this as Respondents Exhibit 3, 2 and 3, Your Honor. I would offer them at this time. No objections. Admitting evidence. Permission to publish, Your Honor. So showing the court and showing the person on the stand. Again, Pink, at 7:44 p.m. on July 28th, 2024, you say, love you. And then what do you call that? An emoji? Yes. Okay, what does that emoji signify? Happy, nervous. Okay, hope you're having a good day. Sorry. Last thing is a thank you. Can I suck you? Or I assume you meant your dick tonight. And then another emoji. And what does that emoji signify? A mouth opening. Okay, and this was the day before you went into Austin Oaks. Yes. And when you went into Austin Oaks, they did a screening process with you. Is that fair? Yes. And they would have, Judge, may I approach? Yes. Are you going to introduce all of the records? Her lawyer asks. I am. That is excerpts I have. They're voluminous, so I have them on a flash drive. Judge, I don't have an objection, but I think the entirety of the records need to come in, not just the sections. I don't know if they're coming in under the business records affidavit. Man, do you really not have a copy of everything prior to this? I guess maybe because you're in the pre-stages still? Damn, so that sucks, but maybe because it's like a temporary restraining order and everything beforehand, I guess. I don't know. Damn. Judge, I have a copy of the electronics copy of the record. Okay, so you're offering the electronic copy of the entirety of the records, correct? Okay, is that respondents 4? Is respondents 4? And I'll represent to the court and opposing counsel that that's what they are. Okay. Any objection? No. In its entirety? No. All right. Okay. Judge, can we take a comfort break? Sure. How much time? Not much. I think after this witness, we'll take a lunch break. Maybe not an entire hour. Brief recess. Please proceed. Thank you, Your Honor. Cross-exam. Tectone's lawyer. I don't know. They don't send that. I forget that. Pinkchyu, again, I think when we broke, we were discussing you going into Austin Oaks. Yes. And before you went into Austin Oaks, you sent John or Tectone a series of text messages that you guys had a text conversation about your decision to go into Austin Oaks. Is that correct? Yes. And that's what we see on the screen behind us. Is that fair? Yes. Our discussion, yes. And you said, I really need a friend right now. I think I need to go to the mental hospital. My mom doesn't answer. I don't know if the medicine, I'm having a hard time. I need to see a doctor, figuring it out right now, packing my bags, heading to my mom's. I hope you see this, but I'm going to do the right thing and get a full psych evaluation and get some real help. I love you so much. I'm sorry if I ever hurt you, and I can't wait to come back feeling better. I love you. Is that what you wrote? Yes. And did John direct you to write any of that? No, not that. Okay, just the other part about the oral sex that evening? Yes. Okay. But that was the only part that he directed you to write? No, he's done it before. If she has evidence of that, that would be pretty big, but I don't know if that's been submitted anywhere. Okay, and then he responds, Jesus Christ, all right, well, be safe and trust your decisions. Okay. Is that correct? Yes. He doesn't belittle you? Not in that text. Correct. In that text, he doesn't belittle you? No, not in that text. Okay, he doesn't call you crazy? Not in that text. He doesn't call you psycho? No. Okay, he says, if you need me, just text me. I have my phone now. I am so sorry you're going through this, Pink. Correct? Yes. Okay, he's supportive in those texts. Okay, sure. And for sake of our questions about those text messages, that's what I'm referring to. Okay. In this group of text messages, he's not dismissive. No, he doesn't use any pejorative language, crazy, psycho, anything like that. Is that fair? Yes. Okay, and in fact, when you message him, hey, he says first thing, hey, are you safe? Yes, that's the priority for him, is making sure you're safe. Okay, is that correct? If that's what I'm not him, I can't tell you. Okay, but that's what it reads as. Right, but that's what he wrote. Is that correct? Yes, that's what he wrote. Okay, and then you respond with, I'm safe, yes, trying to figure this out. And he doesn't say, cool, don't care, good luck. He says, okay, keep me updated. Yes, and then you describe your sister coming to take you, going to Del Seton, and then you eventually say, they're probably going to take my phone away. In other words, don't be surprised if I don't call or message. Is that fair? Yes. And you say, John says, everything will be okay. And you respond, I love you so much. Please don't tell anyone. And John replies, 100%. Are you with your sister? Yeah, she's on her way. Can I call again? If not, that's okay. And he says, I need you to be strong. Yes, correct. Witness nods head. Again, he's supportive. He's encouraging you. He's encouraging of you, getting whatever acute mental health crisis you have going unaddressed. Is that fair? I just wasn't feeling good. It wasn't acute. Okay, we'll get into that in some of those medical recordings or medical records. I mean, at the time, were you having some feelings, some thoughts of self-harm? I mean, yeah, I was. Okay, in a bad situation. Sure, and okay, maybe you have a different definition of an acute mental health crisis, but you felt like you needed to go. I just needed to get out of there. Okay, and then again, John says, text me when you're on your way and please be safe, be careful. Correct. And you eventually tell him, I'm going to Austin Oaks. And that's when you check yourself in. Yes, is that fair? Yes. Okay, and I want to ask you about that process. And when you go into Austin Oaks, they ask you a bunch of screening questions. Is that fair? Okay. Somebody said that Tectone's cross-examination was interesting for this. Actually, hold on. I'm doing a poll and if I should read the rest of this.